Florida. I looked up.
Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. I want to start off with an apology to all channel members for not being able to do the pre-show this morning, but the tech issues appear to be solved. Let's check out Judge Wade Mercer. He's doing first appearances. We'll start there.
It looks like you may be, but that'll be a final decision made by that judge in that county. Any questions, Mr. Miller?
No, that's it.
Have a good day, sir.
Okay.
Jason Pollock. Mr. Pollock, good morning. Mr. Pollock, you have a couple of issues. You have a violation of state probation allegation, and that warrant has no bond on it, signed by the circuit judge. You're going to be held with no bond until you can get that case resolved. We'll come back to that in just a second. You also have a child support matter. The child support matter does have a purge on it of $1,025. So if you post the $1,025, that case will be over with, but you wouldn't get out of jail because you've got the no bond in the VOP. So you got two different issues. Back to the violation of probation. I want to get you arraigned, and I want to get a lawyer appointed to represent you if that's what you're asking for. Mr. Pollock, you want an attorney appointed to represent you in that VOP case?
Yes.
I'm going to appoint the public defender's office to represent you. Listen to Mr. Blunt, and then we'll make sure you get a court date, and then I'll see if you have any questions. Mr. Blunt.
Your Honor, we acknowledge to see the affidavit of violation, waive formal reading, enter denials to that allegation, and I believe we set Mr. Pollock for a court date on July the 10th, and Mr. Green will be out to see him.
July the 10th. Mr. Mitchell, anything?
No, Your Honor.
So Mr. Green will come see you before your court date, which will be on July 10th. Mr. Pollock, any questions?
No, sir.
All right, have a good day, sir. Russell Green, Jr. Mr. Green, good morning. You're here because you have a child support warrant that has a purge on it of $1,500. Let me see what county that's out of. Your child support matter is out of Jackson County. In addition to that, you have a warrant out of Calhoun County. The Calhoun County warrant has no bond on it. That's for aggravated stalking. So if you post the Jackson County charge, then you'll go to Calhoun County and deal with a criminal case down there. Excuse me, if you post the Jackson County purge. If you're not able to post the purge, you'll come to child support court here and then deal with the Calhoun County allegation against you at a later date. Do you have any questions?
No, sir.
Have a good day, sir. Edric Smith. Mr. Smith, good morning. Mr. Smith, you're here because you've been accused of, good morning. You've been accused of one count of possession of controlled substance with intent to distribute. I've read the complaint. There is probable cause for the charge. Mr. Smith, I've also looked at your criminal history, and that led me to the Department of Corrections website. And according to that website, you've been out of prison about 2 weeks. Is that right, sir?
Yes, sir.
All right, I'm going to set you a bond because I think you're entitled to a bond. The reason you're entitled to a bond is, as far as I can tell, you're not on probation anywhere. Is that correct?
That's correct, sir.
And you also have no charges pending that I see. Is that accurate?
That's correct, sir. Can I say something?
Sure.
Well,
Don't talk about the charge. Don't talk about the charge. Your attorney don't want you to hurt yourself, but if you have something you think I need to know for bond purposes, I'll certainly will listen to that.
I would like to, rather than you, let me do it, Mr. Smith. I think what Mr. Smith is indicating, or what he would like me to indicate, Your Honor, taking as consideration is essentially it was a constructive possession case. The other individual he's involved with had actual stuff found on them. However, nothing was found on Mr. Smith's person. There's indications of movements during the chase prior to the car getting stopped. Mr. Smith explained to law enforcement that during the chase, the phone had fell on the floor, and that was the basis of the movement, but nothing was found on his person. There were 6 baggies in the seat, and that was the only thing, but there is nothing indicating that Mr. Smith had actual physical possession or control over any of that. It was found in the center console and outside the car, but nothing on his person.
The 6 baggies that were allegedly found in the seat, were they the empty baggies or were they ones?
They were the empty baggies. I believe the 6 baggies that were full, I think may have been in the Coke can or Pepsi can that was outside 5 to 6 yards from the car that contained the alpha PIHP.
Located in the passenger seat of the vehicle where Edric Smith was sitting was a plastic baggie that held 38 small empty baggies. Okay. Thank you, Mr. Blunt. I see
Yes,
what
sir.
you're talking about now.
I just asked the court to take that in consideration. That's what Mr. Smith is wanting to address the court with. I was trying to do it with.
Yeah, it's not even my car.
To
I'm
it.
just catching the ride.
Hold on, Mr. Smith. He knows it was
Yes,
not
sir.
your car and you were a passenger, so just hold on.
Mr. Mitchell, anything from the state?
Just that no matter what bond you give him, we request that you be subject to random UAs.
Mr. Smith, this is a second degree felony, so I'm probably going to set you a little bit lower bond than I normally would set for this charge. And the reason is the things that Mr. Blunt has pointed out. I'm going to set your bond at $10,000 cash or surety. Again, that's a little lower than normal because your criminal history is not good at all. But
Yes, sir.
it was in your empty baggies were allegedly in your seat. And for that reason, I'm going to set you a little lower bond than I normally would because because of the circumstances in the complaint. So your total bond is $10,000 cash or surety. That means you can go through a bondsman, Mr. Smith. If you go through a bondsman, they charge you 10%. That would cost you about $1,000 to get out of jail. Mr. Smith, you do have a condition of random urinalysis as part of your bond, and you will get to use the phone in just a few minutes to try to post the bond. Do you have any questions?
No, sir.
Have a good day, sir.
Yes, sir.
Frank White. Mr. White, good morning. Mr. White, you're here because you have
Morning,
four
sir.
new charges. Good morning. You've been accused of one count of fleeing law enforcement lights and siren active, one count of tampering with physical evidence, a possession of cocaine, and a trafficking in phenethylamines. Mr. White, there is probable cause for those four charges. And in your criminal history, it looked to me like you just got out of prison roughly a year ago. Is that right, Mr. White?
Sir.
All right. So I'm going to set you a bond, but before I do so, let me see if the attorneys have any additional information they want to make sure that I'm aware of. Mr. Mitchell
Just that you be subject to random UAs.
and Mr. Blunt.
Your Honor, since being released from the Department of Correction, Mr. White is gainfully employed in Tallahassee. He's working, he's been working there for approximately 7 months. He is, has close ties to the Jackson County community. I don't believe he would be a flight risk, so I'd ask the court to take that into consideration that he is employed and not a flight risk. There is some other things with the case. However, at this time, I don't want to go into them on record just to protect Mr. White's rights.
Okay, thank you. So, Mr. White, the biggest problem I have, two things. One's a trafficking charge. That's a first-degree felony charge with a minimum mandatory. And the second thing is what I already pointed out. You've been out of prison about a year, and you've got these charges. The evidence against you appears to be substantially greater than the evidence against your co-defendant. The trafficking bond is going to be $75,000. The possession of cocaine bond will be 10. Tampering going to be 10. Fleeing and eluding will be 25. Your total bond today, Mr. White, is $120,000 cash or surety, sir, and you do have the right to use the phone for purposes of trying to post a bond. I'll see if you have any questions in just a second. You do have a condition of random urinalysis. What that means is if you post a bond, you can be drug tested at any time by a judge or anyone the judge designates. Also, I'm taking into account the danger that the complaint describes based upon the traffic chase and the eventual contact between your vehicle that you were allegedly driving and law enforcement's vehicle, which could have caused injury to someone because you allegedly failed to follow their instructions to stop. Now, don't talk about your charge. I don't want you to hurt yourself, but if you have a question, I'll be glad to try to answer your question if I can. Any questions?
What I was going to ask you is, sir, how do I have a trafficking charge?
Trafficking has to do with the amount of the substance. The amount of the phenethylamines is over the threshold for trafficking. So trafficking is possession of a substance, of a large enough substance with intent to distribute it. That's why you have the trafficking charge. It's a cumulative effect of the baggies, the substances, the way the substances were packaged, and so forth. That's what led to the trafficking charge.
But I didn't have, none of that was on me. I only had just what I had got found on me was just
Hold on, don't talk about what you had on you. I mean, I know it's in the report.
According to the complaint, it was thrown out your driver's window on your side of the vehicle, thrown outside, and they found it outside the vehicle. That's what you're accused of. Not saying they haven't proven that. That's just what they're accusing you of at this point, and your criminal history is not good. And the driving pattern certainly indicates you were affording law enforcement for a reason, and the reason was allegedly you had a felony amount of controlled substance on your person or in the vehicle at least. you have any other questions?
Now, real quick.
Sure.
Mr. White, per our conversation, if their lights and sirens are activated, hopefully they have audio and video equipment equipped on those vehicles. Therefore, we'll be able to see. That's why I don't want you talking about the case.
Yes, sir.
Also, fingerprints can be tested, the can be tested. So you have defenses. Just sit tight. Once we get the discovery on the case, we can look at that and make a motion for bond reduction at a later date. Don't say anything this
Yeah.
morning that'll hurt you. Got me?
I just know that, but if the bond is set so high, and for me to really go back to work, like that's a lot of money, like to try to bond out because of saying that I got trapped. And
But that's what we dealt with this morning. So just sit there and let's protect your rights, okay?
If that charge changes, Mr. White, that bond's going to come down. If the charge comes to possession with intent or regular possession, or the charge is dismissed, that bond will change dramatically. But given that you've had a trafficking charge and there's probable cause and you've been out of prison about a year, that's a reasonable bond for today's purposes for the limited information I have. I do wish you the best, sir. We have Jason Miller next. Mr. Miller, good morning, sir.
As Mr. Miller approaches, I tried to advise him what that charge may be up there in Alabama. I've never heard of sexual torture. I don't know what it's punishable by. So I told him he would just have to wait till he spoke with an Alabama attorney or was appointed one.
Yeah, Mr. Miller, I've never seen that charge before either. So I'm not familiar with that charge. We don't have that particular charge in Florida. We may have something similar that's called something different, but you clearly have a warrant out of Alabama. They're saying they want you for that offense up there. And I know that you've had a chance to talk to Mr. Blunt about the waiver of extradition process. Do you have any questions about that process, Mr. Miller?
No, sir.
And do you want to waive extradition and go to Houston County, Alabama and address this allegation against you? Or do you wish to contest extradition?
Whatever the public defender suggested.
Your Honor, I suggested that he would waive and this court would give Alabama a reasonable amount of time in which to come get him. I advised him that the waiver of extradition process, that if he contested, they
Long. Houston County is probably going to have you in Houston County, Alabama. Today's Wednesday. There's a good chance they're going to have you there this week. I can't promise you that. I'm just telling you that's pretty normal. They're very prompt and efficient. What I do is I review the cases at 15 days. So if you're still here in 15 days, I'll see you. I'll get an update from the jail and you'll get to hear that update. I've been a judge now for 12 and a half years. I've never seen a Houston County case still here after 15 days. They just don't do that. Typically, they're going to pick you up within a week at most. And then the other thing you need to be aware of is under Alabama law, what I've been told repeatedly is that you may get a bond, but you cannot get a bond for an Alabama case until you're physically present in that state. So even if there's a bond on this warrant, you couldn't post it until you're physically in that state. So that's another thing you need to take into account. So if you want to waive extradition, you can sign it today. If you don't, that's okay too. I think you understand the process. Do you know what you want to do?
Yes, sir.
And what is that? Okay.
Sign
So
it.
the corporal has a form for you to sign there to waive extradition. And Mr. Blunt, you satisfied he's made this decision freely and voluntarily?
Yes, sir.
So Corporal, if Mr. Miller is still here in 15 days, please put him back on the first appearance list. As I just mentioned, Mr. Miller never had that happen before with Houston County. I've had it happen, but not with Houston County, Alabama. They're very, very likely they're going to get you within the next few working days. And then when you get up there, you'll find out if you've got a bond or not. Any questions? And if you do get to use the phone after first appearance, so you can contact friends or family, and the friends or family can go ahead and call Houston County and ask if there's a bond on the warrant. You can't post it till you get there, but at least you would know once you get there if there's a bond or not. Okay?
Yes, sir.
Have a good day, sir. Corporal, anything else from the jail this morning?
No, Your Honor, that was it.
Mr. Mitchell from the state?
No, Your Honor.
Mr. Blunt?
No, sir.
All right. Thank y'all very much. That concludes first appearances. Don't miss any.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Wednesday to you. Again, an apology to channel members that we weren't able to do this morning's pre-show. Luckily, the tech issue that I found this morning was a fairly quick fix, so we were able to make the live actually a little bit early. But it's amazing. You sit down the night before, you get everything ready to go, and then you sit down the next morning and everything's different. There are gremlins, I swear to heavens, it's the truth. Let's go to Mindy Glazer, Miami-Dade. We'll spend a few minutes with her.
Thank you. Is he here? Oh,
Fernandez?
I'm looking for Camilo Fernandez. Let me take a break and you guys can get your act together to bring him in. Okay, what about Ronald Sullivan? Is he here? How about anybody who's here?
Donna, you could take the person on the Zooms.
Okay. Well, now somebody's here.
Now we have Mr. Camilo Fernandez here.
Good morning, sir. Do you speak English?
¿Habla inglés, señor?
Little bit.
Thank you, sir. You were arrested on a warrant from Brevard County, Florida. The warrant was issued June 18th of 2025.
¿Puede interpretar?
He needs a Spanish interpreter.
Bien, señor, buenos días. Usted está aquí, tiene una orden de arresto del condado Brevard emitida el 18 de junio del 2025.
We'll appoint the public defender's office to represent you on the warrant.
Le asigno el abogado de oficio para que le represente en cuanto a la orden de arresto.
Charges are, the warrant is for illegal use of a credit card, $15,000 bond.
Aquí tenemos esta orden con acusaciones del uso ilícito de una tarjeta de crédito con una fianza de $15,000.
Criminal use of personal identification, $15,000 bond.
Además, el uso penal de identificación personal, $15,000 de fianza.
Burglary to an unoccupied conveyance, $15,000 bond.
Además, también por $15,000 de fianza, el allanamiento de un medio de transporte o vehículo.
Grand theft, $15,000 bond.
Hurto en mayor cuantía, $15,000 de fianza.
Traveling across county lines with the intent to commit a burglary, $50,000 bond.
Además, por $50,000 de fianza, tiene el haber cruzado, el haber viajado a través de las fronteras de los condados con la intención de cometer un allanamiento.
Theft of a credit card, $1,000 bond.
$1,000 de fianza por el hurto de una tarjeta de crédito.
So for this case, the total bond is $111,000, it looks like.
Al parecer, el total de la fianza de este caso es de $111,000.
You have another warrant for, or another case for illegal use of a credit card, $5,000 bond.
Tiene otro caso donde también enfrenta acusaciones de uso ilícito de tarjeta de crédito, $5,000.
Criminal use of personal identification, $5,000 bond.
Tiene además el uso penal de identificación personal, $5,000 de fianza.
It looks like burglary to an unoccupied conveyance, $5,000 bond.
El allanamiento de medio de transporte no ocupado, $5,000 de fianza.
Grand theft, $5,000 bond.
Hurto en mayor cuantía, $5,000 de fianza.
Traveling across county lines to commit a burglary, $15,000 bond.
Y el atravesar o viajar de las líneas o fronteras entre los condados con la intención de cometer allanamiento, $15,000 de fianza.
Total bond for both cases is $147,000.
Y el monto total de la fianza para ambos casos es de $147,000.
So if you're able to post that bond, you can do so at the jail you're located at. If you don't have any money to post a bond, you will have to wait up to 15 days for Brevard County to pick you up.
Entonces, si usted tiene los fondos para pagar dicha fianza, lo puede hacer en la cárcel donde está radicado en estos momentos. De lo contrario, tiene 15 días a esperar a que el condado de Brevard venga a recogerle.
The reset date is July 10th to make sure you either were transported to Brevard County or posted a bond. Have a good day.
Su próximo día en calendario será el 10 de julio para confirmar que le hayan recogido de Brevard o que usted haya pagado la fianza. Tenga buen día.
Next case we have is Ronald Sullivan.
Right here, Mr. Sullivan. Okay, okay. And Your Honor, after this case, we have Ms. Hertz from earlier. I'm ready.
Who?
Ms. Hertz?
Miss Hertz?
Ms. Hertz, yes, Your Honor.
Okay. Was that the extra out-of-state warrant calendar?
Yes, Your Honor.
All right. All right, good morning. This is Mr. Ronald Sullivan. Sir, you have an arrest warrant from Broward County. It was issued April 21st of 2025. It's a municipal ordinance violation, lodging on private property without consent, $150 bond. And then it looks like carrying an open beverage in public, $150 bond, total bond $300. I will appoint the public defender's office for you. If you are unable to post a $300 bond, then you will have to wait up to 15 days for Broward County to pick you up. The reset date is July 10th to make sure you either posted a bond or were transported to Broward County. Have a good day, sir. All right,
Thank you.
next up is Trinell Wheeler. While we're waiting, I'm sorry, you wanted Brianne Herx? Sorry, I
Yes,
forgot.
Your Honor.
Brianne Herx. Hi, Ms. Herx. Good morning, ma'am. You have a local
Morning.
you're in Miami, so you're not ready to go to Kentucky yet. The next court date for your Miami case is July 2nd. So we're going to reset this out-of-state warrant case for July 3rd to see if you've closed your Miami case.
Yes, ma'am.
Have a nice day. Thank you.
You too.
Now we have Trinell Wheeler. Actually, I have Mr. Nordello on Zoom. Oh, wait, Mr. Wheeler's there. Let me deal with Mr. Wheeler. Hi, sir. Good morning.
How you doing, ma'am?
Sir, you got a warrant from Osceola County. The warrant was issued June 20th of 2025. Failure to appear for an arraignment. Your total bond is $2,000. I will appoint the public defender's office for you. If you're able to post a $2,000 bond, please do so at the jail you're located at. If you don't have money for a bond, you will have to wait up to 15 days for Osceola County to pick you up.
I'm so sorry. Do I pay the whole 2,000, ma'am?
Yeah, whatever amount that's a contract between you and your bondsman, so it's up to you. Usually they take a percentage, but I don't know what they charge the bondsman. You have to reach out to one, okay? The reset date is
Thank you.
to make sure you either posted a bond or was transported to Osceola County. Have a nice day.
Thank you.
Thank you, sir. Now we have Marlon Gastel Hernandez on Zoom on pretrial. Good morning, sir. English? Do you speak English?
No.
Spanish, please. Sir, you have an arrest warrant from Pinellas County, Florida. The warrant was issued July 20th of 2022.
Muy bien, señor. Buen día. Usted tiene una orden de arresto del condado Pinellas emitida el 20 de julio del 2022.
The charges for grand theft of a motor, failure to appear for grand theft of a motor vehicle.
En el no haber comparecido a responder ante la acusación de hurto en mayor cuantía vehicular.
It says no bond. Corrections, do you show no bond?
Aquí se indica que esto no tiene fianza. Le pregunto a correccionales si ellos ven lo mismo.
I'm checking, Your Honor.
Verificando.
Lo que tengo es probation.
What I have is a probation.
Oh, it's no bond on it. So you're going to have to wait up to 15 days for Pinellas County to pick you up.
Si esto no tiene fianza aquí, así que va a tener que esperar los 15 días hasta que el condado Pinellas venga a recogerle.
¿A partir de cuándo tengo que esperar?
¿Perdón?
¿A partir de cuándo?
Starting counting from what day do I have to wait?
Right now, today,
A partir del día de hoy, 15 días.
reset is July 10th to make sure you're picked up by Pinellas County. Have a good day.
Aplazamiento hasta el día 10 de julio para confirmar que el condado Pinellas le haya recogido. Tenga buen día.
Next,
Good
we
morning.
have Anthony Nordell.
All right, let's switch things up a little bit. Let's go to middle of nowhere, Michigan, St. Joseph County, and we'll see Judge Middleton. He is doing a formal traffic hearing, which he doesn't do many formal hearings in his court. So let's see what's going on there.
Chicago Road in Ottawa for disobeying a traffic signal. The ticket says he went through a solid red light. There was an informal hearing with the magistrate earlier, and the defendant appealed that and asked for a formal hearing. That's in front of the judge. He posted a bond, and the matter is set for trial this morning. Mr. Timothy Reed, the Sturgis City Attorney, is present. As well as Officer Dylan Ware of the Sturgis Police Department, who issued the citation. The fine, I believe, was $120. The defendant did post bond in that amount. The plaintiff filed a jurat earlier this week, formally charging this as disobeying a traffic signal. Good morning, Mr. Reed.
Good morning, Your Honor.
What's the people's position here?
I guess if the defendant still wishes for the hearing, we're prepared to move forward with the hearing.
Is that what you wish, Mr. Summey?
I would just would like to see if there's any options as far as me getting a fine and not having to get the points on my license and stuff like that, because I wasn't expecting for me to be broadly punished for this citation, because if I had not stopped at the red light and I had just gone through it and almost hit somebody, I'm getting the same charge and the same amount of points, and there's no degree to it like speeding or anything like that. So,
well, the traffic code, the Michigan Motor Vehicle Code, has a schedule of crimes and civil infractions, and there are points assigned to each offense and fines by fee schedule. This is a civil infraction. It's not a crime. You don't get convicted of guilty of a civil infraction. You're found responsible or not responsible. You can't go to jail for a civil infraction. And the burden of proof is lower. In a criminal case, you have to prove guilt beyond a reasonable doubt. In a civil infraction case, you only have to prove guilt beyond a preponderance, which is 51% to 49%. So it's a lower burden of proof. It's not a crime. You can't go to jail. You've already paid the fine. The officer's here on overtime. He came in once before to testify. He's here again. Mr. Reed, any response to that?
I mean, we're here for the hearing of, the charge is the charge.
Yes, so the city's not willing at this point to alter it. With that in mind, you just want to pay the $120 fine and you wish to have a hearing on this.
if I pay the fine, am I gonna get the points and stuff?
Yeah,
like
you're
that?
gonna get 2 points.
Well, then, yes, I'd like to continue this.
All right.
I mean, if people can sit in jail and fight their case and have it get dumbed down, all because that the courts don't want to go to trial and they'll just give them a better deal. I don't understand how I can't get at least a warning on this, and I'll never do it again. I've definitely have learned my lesson there, but I don't feel like I should get the points if I came all the way up to the stoplight and I stopped.
Well, we haven't gotten to the facts yet. So I don't know, but right now you have 0 points on your driving record, so this isn't gonna cost you your driver's license. You've had some points in the past, but they've all gone away, so you have 0 points. In fact, even with this on there, it shows 0 points. This carries no points.
It carries points. It's just when they appeal, it doesn't
Oh, they hold the
abstract.
points, all right, okay. I thought it carried 2 points.
It does.
All right, so you're not gonna lose your driver's license. You're gonna get 2 points on your driving record. You've already paid the $120 fine. So I'll use your bond to pay your fine. The case will be done. But if you wish to have a hearing, the city's ready to go forward.
Yes, I would like a hearing if the.
All right, well
charges
then
are
let's
gonna
just go
get
through it.
changed.
Okay. My first witness is Cole Summey.
All right, well, let's have Mr. Ware and Mr. Summey both raise their right hand. Mr. Summey, you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, Your Honor.
All right, in a civil infraction, because it's not a crime, you don't have the right not to testify. So the city is calling you as a witness. So would you come up and have a seat in the witness box? Your name is Cole Aaron Summey?
Yes, Your Honor.
All right, very good. Mr. Reed?
Thank you. Does court need the spelling of his name or is it?
No, we got it. Summey.
And Mr. Summey, you were operating a motor vehicle within the city of Sturgis on April 27th, 2025, correct?
Mhm.
Is that a yes or no?
Yes,
And you were on Nottawa Road at or near Chicago, meaning US 12, the main intersection there, Nottawa Road, at around 11:36 in the morning. Is that correct?
yes.
And at that time, you came to the red light that was facing your direction,
You said 11:30 in the morning?
11:30 at night.
Oh.
Is that correct?
Yes,
And you were traveling southbound on Nottawa, is that correct?
yes,
And you came to the intersection of Chicago and Nottawa Road to a red light, is that correct?
yes.
And you proceeded through that red light before it turned green, is that correct?
Yes, only because I didn't feel any resentment towards the fact that it's 2025. And I wouldn't expect tax dollars to go towards something that could easily tell me that there's no traffic. So I told myself, I made a citizen's good to go on that one.
You made citizens good to go that you're going to disregard the red light because you didn't feel
I
there was any
didn't
risk.
disregard it. I regarded it and then,
Didn't stop for it,
oh, I stopped.
but didn't wait till it turned green.
Correct.
So you understand that the traffic law requires you not to proceed until the light is green?
Yes, but I feel like that would just be going against what I know is right.
No other questions, people rest.
All right, Mr. Summey, is there anything else you'd like to tell me?
I mean, I just hurt my feelings to think that just because the light didn't turn green, I'm getting charged with disobeying the traffic signal. I didn't disobey it, but I didn't wait for it to tell me I'm good to go.
Okay, I'm not aware of a citizen's good to go. This is the busiest the second busiest intersection in Sturgis.
Every night that I get out of work and I go there, I'm sitting there unnecessarily. But like I said.
Now, they did change the law. You can turn left on a red light, right on a red light these days, but you can't just blow through it. I don't make the law, and you've essentially acknowledged that you committed it. There is no citizens good to go. You felt like nobody else was coming and you could just go through it.
Well, I knew no one else was coming.
All right, well, that ain't what the law says. All right.
Don't you feel like that's a little unconstitutional? It's like something that is just a machine, like clockwork, this thing. And you as a citizen have to sit there. I really doubt our forefathers would be sitting there.
Well, maybe so. I don't think it's unconstitutional, and I don't think the Constitution envisions a red light. So you've wasted my time, caused a bunch of overtime for the Sturgis Police Department, so maybe that's some satisfaction.
It is a waste of time, really, but how is it on me?
Well, I find that you're responsible for the violation by your own admission. I'll use your $120 bond to pay the fine. 2 points will go on your record that won't cost your license. My suggestion is stop next time or you get another ticket
I
for
did
the same.
stop, Your Honor.
All right, very good. Mr. Summey, you're good to go.
Thank you, Your Honor.
Thank you.
Well, that was special. I'm glad we went there. That was entertaining. I hope you guys enjoyed that. Let's go to Louisiana. I know we went there a couple of times yesterday, but I want to go there just because I've got it frozen, and this is what we're starting with today. So I'm intrigued by this guy already just looking at him. So let's see what it's all about, shall we? Hang tight just a sec, and we will get it rolling. All right, let's go.
Session. We are at Orleans Justice Center. Please state your name and DOC number for the record. You're on mute.
Danny Ryan DeSalle, 546483.
Okay, Mr. DeSalle, today we're here for your revocation hearing. Is there anybody in the room with you?
No, sir.
Okay, my name is Pete Freeman. I'll be the acting chair. Mr. Ledoux is to my left and Mr. Byron to my right. They will be the board members today. Do you have a questionnaire with you that was filled out? You have paperwork?
Yes, sir. Yes.
Okay. Did you sign and state and realize you're not eligible for appointed counsel?
I signed.
But you do have a public defender here.
Oh, yes, sir. I got my public defender. Yes.
Okay. All right. So what we're going to do, Mr. Dressel, first off, I'm going to read all of the violations that you're charged with. You either plead guilty or not guilty with or without a statement. At that time, we're not going to discuss it, okay? We're going to wait till later. Your case has been assigned to Ms. Ledoux. She will ask you questions about your violation. We'll also hear from, let's see, Miss Erica Fust, Orleans Public Defender and Social Worker. We'll hear from her at the proper time. And we'll hear from Rebecca Goldstein, Orleans Public Defender Attorney.
Yes.
Okay, so we'll hear from them at the right time. Okay. First off, you're charged with violating condition number 3. 1130 Oretha Castle Haley Boulevard was listed, addressed on your certificate. 1002 Napoleon Alville was then claimed as your residence during your intake process. You moved from that address to 2239 Porter Street without informing probation officer, as evidenced by your statements to your previous case manager advising this agent that she has not seen you at 1002 Napoleon in a couple of days. It was determined that you were not residing at 1002 Napoleon since 11/18/24 and 11/27/24. Your new residence of 2239 Porter Street was verified. They attempted to contact you at this residence and both were unsuccessful. It was determined you were not staying at 2239 Porter Street, as evident by the staff work advising this agent that you have not been there in the program for about a month. On 1/30/25, this agent attempted to get into contact with you via telephone, and both of your phone numbers on record in the answer machine indicate that both numbers were out of service. Your whereabouts were unknown. A warrant was issued for your arrest. How do you plead to violating condition number 3?
I plead guilty, but I want to make a statement saying
I was at the proper time. Okay. So I'm gonna put plead guilty with a statement. Okay. Let's read your other violations. Okay, it says you violated condition number 4 on 3/12/25. You were arrested by the New Orleans Police Department and charged with aggravated battery by cutting under item C 10922-25 on 5/5/25. The charge of aggravated battery of cutting was refused. How do you plead to that charge?
Not guilty.
Okay. All right. Condition number 5, it's determined that you were in possession of a dangerous weapon as evidenced by your arrest by the New Orleans Police Department, where you were charged with aggravated battery by cutting under item number C 10922-25. On 5/5/25, the charge of aggravated battery by cutting was refused. How do you plead to that charge?
Not guilty.
Okay. Number 6, you have never provided proof of employment. How you plead to that charge?
Guilty.
Okay. You failed to provide a valid address of record. Contact could not be made with you and your residence could not be verified, thereby preventing contact from probation and parole. Your whereabouts were unknown. A warrant was issued for your arrest on 2/23/25 for absconding supervision. How do you plead to that charge?
Guilty with a statement?
Guilty with a statement? Yes.
Guilty.
And the last charge is that you were $315 behind on your fees. How do you plead to that charge?
Guilty.
Okay, let's hear from the people that are here to speak on your behalf, and then we'll let Ms. Ledoux do the interview. Okay, Miss Erica Fuse. I'm sorry if I pronounced that wrong, Miss Fuse.
It's okay.
Okay, what do you have to tell us about Mr. Dussel?
Good morning. My name is Erica Fuste, and I am a social work intern with the Orleans Public Defenders. I'm speaking today on behalf of my client, Danny Dussel. Since his arrest for his refused charge out of Orleans Parish, Mr. Dussel and I have been meeting on a bi-weekly basis. In each visit, Mr. Dussel has remained insightful, cooperative, and reflective. Since his release from DOC custody, Mr. Dussel has shown a demonstrated commitment to seeking welfare services, particularly housing services, to aid in his reentry and to address his chronic homelessness, substance use, and unaddressed post-traumatic symptoms. Mr. Dussel is seeking to affiliate himself with a structured, positive, and faith-based mentors and institutions to address his long-term goals, a life of sobriety, and stable housing. Mr. Dussel has already been accepted into Broken Wings Recovery Center in Bastrop, Louisiana, which is a Christian and Alcoholics Anonymous-based drug and alcohol residential treatment rehabilitation facility. Broken Wings provides peer support services, medication management, and intensive therapy for clients as they begin to rebuild healthy relationships and heal from the damage that is caused by addiction. If released back onto parole, Mr. Dussel would participate in individual and group counseling and be reintroduced to his faith and 12-step community. Upon successful completion of residential treatment, Mr. Dussel will work with his inpatient team to create an effective discharge plan that includes placement into stable, safe, and sober housing in Louisiana. With the help of his discharge team, he's going to have access to resources that will assist him as he utilizes his 12-step and faith-based support network. Moreover, his team at Broken Wings Recovery Center will ensure that he is connected to case managers to support him in his search for employment and maintenance of his social benefits. Through my work with Mr. Dussel, it's become clear that he is committed to long-term lifestyle changes, included his stated goals of sober living, housing security, and counseling. I offer this statement today in the hope that it can provide context for Mr. Dussel's current situation and be taken into consideration when deciding whether to release him back onto parole. Thank you.
Okay, thank you, Ms. Fuse.
I got a question.
Okay, he has a question for you, Mr.
When you said you've been meeting with him bi-weekly since his arrest, all the way a year and a half ago?
Since
How long have you been bi-weekly meeting with him personally?
This most recent arrest for the charge that was refused, for which he was arrested, I believe, in March. I've been going to the jail, Orleans Justice Center, about once a week, every 2 weeks, to visit him and work through what his plans are post-release.
No other questions? Okay, thanks again. Next, we're going to hear from Rebecca Goldstein, Orleans Public Defender.
Good morning. Thank you for your time today. My name is Rebecca Goldstein, and I represented Danny DeSalle on his now refused charge out of Orleans Parish. Mr. DeSalle is a 38-year-old United States Navy veteran. In 2005, at 18 years old, he joined the Navy after being inspired by his grandfather's own service. While serving, Mr. DeSalle spent most of his time on a crowded submarine for months at a time. And once he was discharged and completed service in 2007, he was formally diagnosed with post-traumatic stress disorder. Mr. DeSalle returned to Louisiana to live with his grandmother. However, unfortunately, without the necessary community support at the time to manage his PTSD, he soon turned to drugs to help him cope. Mr. DeSalle's battle with addiction led to chronic homelessness and incarceration. Despite these challenges that Mr. DeSalle has faced, he is committed to his recovery, as the board has just heard. He's eager for the chance to engage with meaningful support through the reentry plan that we've created so that he can maintain his sobriety, obtain stable housing and employment, and be a contributing member to his society. Mr. DeSalle is before the board today because he is accused of violating conditions of his parole, specifically for engaging in criminal activity, absconding supervision, and failing to pay parole fees. First, I'd like to address the new criminal activity allegations and possession of a dangerous weapon. As the board knows, Mr. DeSalle was arrested on March 12th of this year on one count of aggravated battery, and on May 5th, that charge was refused. Mr. DeSalle has no other pending charges. That charge was refused because Mr. DeSalle did not commit an aggravated battery. On March 12th, a homeless man named James Gum was stabbed. Mr. Gum had told law enforcement that he was stabbed by a man that he knew by the name Jericho. Mr. DeSalle was arrested in that area later that day, when officers mistakenly thought he could be Jericho. He is not. Mr. Gum had never identified Mr. DeSalle as the man that stabbed him, and the stabbed victim, Mr. Gum, has signed an affidavit attached to the packet that was sent to the parole board stating that Danny DeSalle was not the man who stabbed him on March 12th, nor was he the man accompanying that offender. And that's Exhibit 1 in the packet. Mr. Gum further stated that he does not know Danny DeSalle to go by the nickname Jericho, and that Danny DeSalle saw him bleeding after he was stabbed and went to find help. Attached to the packet as Exhibit 7 is also a police report with an arrest warrant for a man named Jericho Miller, who was later arrested, and this arrest warrant is for an incident that happened at the jail where Jericho Miller is accused of stabbing James Gum in the Orleans Justice Center when they were incarcerated together, further indicating that Danny DeSalle is not Jericho and is not the man that was stabbing James Gum on March 12th or at any date, which is why this charge was refused. Regarding the violations that Mr. DeSalle absconded supervision and failed to make payments, as you've heard, Mr. DeSalle acknowledges his mistakes. He takes full accountability for not properly checking in with his parole officer. While he was homeless for the entire 4 months between November and February of 2024, despite seeking out various shelters, Mr. DeSalle's lack of permanent housing made maintaining a reliable routine and consistent check-ins difficult. However, he acknowledges that despite how difficult his situation was, he needed to be more communicative with his parole officer, and that he needs to explain where and how he's seeking services so that his parole officer can always find him. While Mr. DeSalle's lack of housing and criminal record have made it challenging for him to find employment, he knows that he needed to be attempting to make payments regardless and keeping his parole officer up to date on those attempts. If released back onto parole, Mr. DeSalle will receive employment assistance, as the board has heard, as well as training through Broken Wings. as well as assistance from our office, ensuring his ability to make all future payments on his parole fees. Finally, since his arrest on the now refused charge, Mr. DeSalle has been working with social work intern Erica Fuste, as the board has heard. Together, they've created a tailored reentry plan that's outlined in the packet, and that's been addressed today, should Mr. DeSalle be released back onto parole. Most notably, this includes drug treatment and long-term housing and employment support. With the proper support system for the first time in his life, Mr. DeSalle is hopeful to begin a new chapter. He has learned from his mistakes and is dedicated to his recovery and wants nothing more than to have a meaningful chance to be a productive member of his community. We respectfully ask that the board use its discretion today to show Mr. DeSalle mercy. Thank you for your time.
Appreciate it, Ms. Osteen. Okay, as I said, your case has been assigned to Ms. Ledoux, so she'll go over and ask you questions about your violation.
Yes, sir.
Mr. DeSalle, you spent 2 years in the Navy. How were you discharged? Honorably or something?
Other than honorable for I had failed a drug screening. A drug screening, yes, ma'am. Other than honorable.
Other than honorable.
Yes, ma'am.
Okay. So, in fact, you have struggled with substance abuse since 2007, it sounds like.
Yes, when I joined the Navy. I joined the Navy right out of high school. So I was 18, I was pretty young, yes, ma'am. Since 07.
So have you ever, I mean, you're a fourth offender. Have you ever had substance abuse treatment while you were incarcerated?
Yes, ma'am.
And where did you go? What class or where did you go for that?
Oh, they sent me to Stephen Hall. I did 6 months there, and I've been struggling lately here, not so much with the drug abuse, with just being homeless. As far as getting out, I just did 3.5 years, and that's why I was moving from homeless shelter to homeless shelter, and people kept stealing my cell phone and stuff like that. I just been trying to find a permanent job to where I could find some place to live. That's been my main struggle since I've gotten out of prison for that 4 years I did. The incarceration I just did. I've only been out for 4 months, and I've been trying to. It haven't been so much the drugs as it has been the homelessness. Just trying to find a place to live.
Okay, so in your understanding, tell me about Broken Wings. What is this program about? And
It's a program that'll help me for one time in my life, put me in the right direction. It's kind of like I lost direction. I mean, I've changed my life. I don't want to live a criminal life anymore. I don't. I don't want to spend the rest of my life in prison. I want to have help being a successful person in society. I just want to get a little job and have my own place to live by myself. And for the first time in my life, that's what I want.
okay, how long is Broken Wings? How long do you anticipate being there?
Well, I think it's a 3-month program or so, and then it's gonna find me permanent housing and find me a place to live.
What if 3 months is not enough?
I believe it'll put me in the right direction. I had just did 4 years. I need help finding a job. I need help finding a job where I can go to work. And so I can go, so I can find my own place to live. Plus I've been going to class here while I've been in jail, and they put me on a medicine to keep me from doing drugs in this jail, in this program.
Since you've been in this time, you've been taking some classes?
Yes, ma'am. I've been going to a MAT program where they also put me on medication. I've been in here for over 3 months already. So I've had 3 months here. And I've had 3 months, and I've been going to the MAT program.
Okay, perhaps I need to address this issue with Ms. Fusay. Ms. Fusay, I'm not sure the 3-month program is going to meet his need. Tell me a little bit about this aftercare, because
Yes. So Broken Wings, first and foremost, is an inpatient substance use treatment facility, right? So should Mr. DeSalle be released Broken Wings coordinates his transportation from the Orleans Justice Center. They pick him up and directly bring him to Broken Wings. There, he begins a formal process of getting off the medication where he needs the medication that he's currently on that he needs to remain sober. He's going to work through therapists, working through therapists and also with medical professionals to fully get him off the need for any treatment to address his substance use. Upon successful completion of the inpatient program, Broken Wings, the caseworkers there, it doesn't end at 3 months, right? If he is committed to his sobriety, they work with him to find him employment training, sober living, housing options, whether that's on their facility, it's in Bastrop, Louisiana, or if he wishes to return to his hometown or if he wishes to return to New Orleans, they have caseworkers that they bring him back and they still set him up with employment training. They still set him up with housing support and sober living housing. So really the program, he's there for 28 days, but the case management does not stop.
So I don't think that Mr. DeSelle's best chance for success is going to be to ever return to New Orleans personally.
No, I don't want to come back to New Orleans. That's not where I want to be. No, man. That's how I got in this trouble in the first place.
Yeah, he doesn't need to, sorry, Mr. DeSelle.
Yeah.
He doesn't need to return to New Orleans. It's really just that they have the resources all around Louisiana, but most clients, they do end up staying on or near the facility so that they have direct access to their caseworkers, their therapists, their whole community, right? And they provide sober living options and they provide employment training.
I defer to my colleagues at this time.
Okay, I have a few questions, Bara, if you don't mind, I'll go before you. Okay, first off, Mr. DeSelle, what's very, very, very concerning is you've had the best programs that we have to offer. They haven't worked. I mean, you went to Steve Hall, you went through the impact.
Yes, sir.
That you went back to drugs.
Well, no, this time.
But tell me this time it's gonna make me feel like you're not gonna go back to drugs again.
I'm not trying to go back to drugs. I've given up drugs. I'm trying to find a job that I can work successfully and keep that job and get my own place that I want to live in, that I don't have to, I can be by myself and get out of the city. I haven't been struggling with drugs as I've been struggling with homelessness and not being able to find a job. That's what I've been struggling with.
I understand that, but drugs is your main problem. You're not gonna ever find a job unless you get rid of the drugs.
I got rid of the drugs. I just did 4 years. I've only been out for 4 months. I haven't been doing the drugs. I've been trying to find a job. I don't have any money or support. That's why I had no concern on doing drugs. I'm done with the drugs, sir.
Okay, thank you. Mr. Barr?
Y'all covered.
You covered. Okay, is the panel ready to vote?
I am. Mr. DeSelle, first of all, I appreciate your brief stint in the military and do recognize that you are a veteran. I do believe that homelessness is your biggest issue. Based on the information that I've received, I believe that you were not involved in the altercation, Mr. Gunn. You're a fourth felony offender, and Mr. Freeman is correct. You've been through programs, so I don't think going to another program incarcerated is going to help. My vote is going to be in lieu of revocation to send you, oh, well, I can't do that because of this week. So my vote is to do not revoke, but you must go to Broken Wings as a special condition. You go there for the duration of that program, and then you follow any outpatient treatment plan that they request. And while I cannot mandate it, I strongly suggest that you not return to Orleans Parish and that Broken Wings establishes a strong connection with your probation officer. And my vote is to do not return.
Mr. Morrow?
I'm gonna concur on that and vote to reinstate your parole. But added a special condition to what she said about Broken Wings, random drug screens and AA and NA meetings once a week.
Yes, sir.
And understand that you've done had all the chances you're gonna get as a fourth offender. You come back, you're doing time.
I know, and I know.
Who you bring with you to say they're gonna help
Yeah,
you?
I was gonna say, don't worry about next time, ladies, because it won't happen next.
So make sure you get the message.
Yes, sir.
The last chance. You asked for one, they did a good job setting you up. If you don't take advantage of it, you got nobody to blame but you.
I know.
All right.
Okay, and, well, I'm gonna tell you, against my better judgment, I'm gonna vote the same. I'm gonna vote the same. This is your last shot, man. And the homelessness, I understand it, but the drugs is the problem.
I'm done with the drug.
Okay, all right, so today the vote is do not revoke, for you to go to Broken Wings. You to leave from the jail to go to Broken Wing, you to complete the 28-day program and follow any recommended treatment. Make sure that you get in touch with your probation officer once you get to Broken Wings, okay?
Yes, sir. Yes. Thank you all. God bless.
Thank you. Thank you, ladies.
I am shocked. Shocked, I tell you. Super shocked. Double super shocked. Maybe even triple super shocked. I didn't see that one coming. So, Jim, a little while ago, you said older people aren't sold on the idea of rehabilitation. I get what you're saying, but I think it's more complicated than that. And I will tell you, as somebody who's fast becoming a quote-unquote older person, I'm fairly solidly in my 50s now. I don't know how old you guys are, but I'm guessing I'm older than most of you. The more I age, the more my desire for people to be rehabilitated and fix their lives becomes tempered with the reality that some people just aren't going to make the choice to do the things they need to do to get there. You know what I mean? So, I suppose as you get older, you become a little bit jaded in that respect. I want people to succeed. I like it when people do. I'm happy for this guy. I hope he runs with it. But I'm telling you, there's a little bit in my head that says it's not going to work. Just based on where he's at in life, where he's been through, I don't know. We'll see. I hope, but time will tell. I hope all that makes sense. Feel free to discuss more in the chat. We're not going to go there, but I wanted to show you this real quick. This is Judge Allen in Lansing, Michigan, or as I call him, Judge Ringlight. This is the guy who's got a ring light on the bench to keep himself looking just perfect for the camera. Tell me this isn't like a game of Hollywood Squares he's got going this morning. I'll take Blake Sanum for the block. I just thought I'd show you because he's got way too much going on. Let's go to Texas. We'll say good morning to Judge Stevens. Let's do that. Let's make that happen.
5. You have been indicted for the second-degree felony of fraud using apparently fraudulently using identifying information of an elderly individual, namely credit cards, debit card, Social Security, driver's license, without the consent of the elderly person. So if convicted, you are looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000. Do you understand what you're charged with and the punishment range applicable if convicted? Yes, sir. It doesn't stop there. I'm looking at page 2 of the indictment. People in criminal law are punished based upon the circumstances of the crime and criminal history. You've got a rich criminal history. I'm looking at a burglary of a motor vehicle conviction. You're going to interrupt me? Well, let me speak, and then you can talk. States that on paragraph 2 of the indictment, that you were convicted in 1990 in this court, and I was just a youngster, I guess, of burglary of a motor vehicle. Thereafter, that was fine. The next paragraph, the next paragraph, paragraph 3 states that you were in on January 24th, 1991 in this court, cause number 55194. It says you were convicted of of sexual assault, a second-degree felony. After those prior convictions were finalized, paragraph 4 goes on to state that you committed the offense of aggravated robbery, a first-degree felony, and you were convicted of that in 2004 in the 252nd Judicial District Court next door. What this means and how this affects you is, if all of this was true, you are deemed to be an habitual felony defendant, which means you are looking at the punishment range now for you is not less than 25 years in prison. That's the minimum, up to life in prison. Do you understand what you're facing? Okay. Now, Mr. Dusler here is representing you. Are you employed somewhere?
No, sir. I was at Jack in the Bus, but they never did call
I
me.
can't hear you, sir.
I said I was at Jack in the Bus, but they never did call me.
When was the last time you were employed?
Was it great?
Why? Why aren't you working somewhere? Is it because of your criminal history?
Yes.
But okay, so how do you exist? I mean, you got to eat and sleep and things like that. Where do you, how do you pay for?
It's hard out here.
Sir?
It's hard out here, it's hard out here.
Yes, sir. Well, I can imagine it is. But how do you do it if you've got zero income? I don't understand. How can you do that?
This is what I'm saying. I've been DoorDash, kind of smart.
Where do you live? This says 5695 Sunbird Lane. Is that a home? A house?
Yes, with my mom.
With your mother?
Yes, sir.
Okay. Do you have a vehicle? No? How do you get around? Your mom drives you? Okay, food. Who buys that for you? Your mom?
Yeah, I get a welfare, $291 a month, that's all.
Well,
but these charges I have against me right now in front of you, I took a purse out of the radio.
That's, hold on.
Okay, but
Yeah, we don't want to.
well,
There's the prosecutor. You start volunteering anything, he can use it to help his case. So talk to him. There's your confidence man right there, your attorney. But a case gets investigated by the police, then it goes to the district attorney's office. They review it. If they accept it and feel like it's worthy of moving forward, if it's a felony, it goes in front of the grand jury. And then the grand jury makes the decision. So don't be blaming him. It's gone through 3 sets of reviews, and here it is. Now it's in my court. So what we do is 2 options. We'll try the case in front of a jury, or it gets disposed of in a way without a jury. Most cases are that way anyway, by agreed dispositions. Here, once again, if the problem you have is any crime that's a felony above a state jail felony that you commit, you're looking at the rest of your life, no less than 25 years, up to life in prison. But there's a way to avoid all of that, is don't get in trouble, and make the right choices. Also, when was the last time you said you had an income, though? I mean, people are here in front of, I've got thousands of people. I've got 2,500 defendants at any given time here. And some of them are just like you, sir, but they're working. They're working. Very few are. Hold on, you get a chance to speak. When we both speak over each other, the court reporter can't take both people speaking, and Supreme Court has said if the court reporter is interrupted, somebody gets in trouble. It's not going to be me. Now, so, because I'm not going to speak over you, but those are the rules. And it's rhetorical question. Just people are here and they're working in spite of the criminal history. They find work. You got to find work. It's to make yourself independent, not live off your mom. I mean, that's brutally honest, but it's the way it is. And people are working who have criminal histories like yours in this court because they are hiring lawyers too, and they're not dependent upon others. You seem like you're healthy. You ought to be able to find something if you really want to be independent. That's my statement. All right. So Mr. Dusler is a very good lawyer. He's one of the public defenders, and he's going to help you on this case. And you have to know this is a most serious situation when anybody's looking at up to life in prison. And that's what happens when you have a criminal history like this. Any third-degree felony or above puts you in harm's way of life imprisonment from here on. That's why the best thing to do is stay away from trouble. Now, I'm going to let you talk to him, and we're going to, so you can, have you ever talked to him yet? Okay, meet him, hear it a little bit. He'll discuss some things with you. He's a smart man. It'd be wise to follow his advice, but it's at the end of the day, your choice. This is the kind of thing that may be workable. I'm looking at the facts of this case, and maybe there's something that everybody can agree on. If not, that's what jury trials are for, and we tried 600. So we like trying cases. But talk to him, then he'll get back with me, and we'll decide what the next step is. Okay, thank you. Just stand by, and I'll go to Joey Childress. You can have a seat, sir. Joey Childress, that's you, sir. Come on up. Not yet. Yeah, I'm letting him talk to Don. Talk to him and find out what direction. Okay, you're Joey Childress? Yes. Okay, in 25 CR 314, you heard all that. You've got an unlawful possession of a firearm by a felon charge here. Yes. That's what you're charged with on or about December 6th of last year. And a third-degree felony, if convicted, that's what this is, a third-degree felony. You are looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand? Yes. But paragraph 2 states in 2012, in this court, you were convicted of injury to a child. So this third-degree felony, if this prior conviction is true, if you're convicted of a third-degree felony of this unlawful possession of a firearm by a felon, it becomes a second-degree felony punishment. It gets what we call enhanced, because like I told the gentleman before, your criminal law and dispositions, the way people resolve cases in criminal cases, they're based upon 2 factors: the circumstances of the crime and criminal history. So you would be looking at no less than 2 nor more than 20 years confinement in prison if convicted of all of this. Do you understand? Yes. So it's serious. Mr. Dusler, have you had a chance to talk to him at all? Yeah. We spoke this morning. A little bit. All right. Let me look. And also for Mr. Anderson, as well as Mr. Childress here, if you want a jury trial, which you have a right to, if you're convicted, you are not eligible for probation in front of a jury. that would not be an option. It would be, if you were convicted, it'd be just flat time in prison.
No.
And have you not seen this trouble cost?
Yeah.
Okay. You saw the bottom of it, about the synthetic marijuana?
Yes.
In his statement he makes. All right, have a seat, sir, and Mr. Visser is going to be talking to you. In a little bit. John Laurie has been reset.
Yes.
Okay. Leonardo Mendoza.
That's the one that we discussed earlier. It's been re-signed with David Bro.
Okay,
There's a probation company and David's on that case, so I got.
you're representing Leonardo though, right? Mendoza?
Well, I wasn't until now he's been reassigned to David because there's a motion.
David?
Probation.
Okay.
Yeah.
He's going to have, okay, Mr. Groveland needs to be aware so he can help
I need
Mr.
to answer
Mendoza.
keys and then I'll get.
Be on the
David.
NTOP is on the way. Okay. Clarhaney Milton?
I'll call the name.
Clarhaney Milton. I've never seen a first name like this. That's a new one. Clarrahnie. Clarhaney. And there's no answer here in the courtroom in cause number 23 CR 905. I asked the bailiff to call into the hall for Clarhaney Milton. There's Mendoza. There's no answer to that name being called into the hall. No answer to the name called here in the courtroom. Defendant has failed to appear. A warrant shall be issued for her arrest. What is her bond?
10,000 on it.
Okay, let's see. We've got actually two cases. 23 CR 905 is a state jail felony of forgery. And 23 CR 907 is a state jail felony of fraud. Each alleging on or about January 31st, 2023. The defendant committed these offenses. And so defendant has failed to appear in each of these cases. It's the bond is 5,000 on each case?
10,000.
10,000 on each case. These bonds are revoked as the defendant has failed to appear. Warrants shall be issued for her arrest. The bonds are now $20,000 on each case, plus the defendant must have a GPS device as a condition of bond. Does everybody see when these cases were indicted? July of 23. This is her initial appearance.
She just heard.
I know. I think a GPS device is very important on this one. You know. Wow, that's going on 2 years, and this is her first appearance. Interesting. Okay. Well, she's purportedly living in Port Arthur, but we'll see. Justin Moore, three cases.
All his name, don't sir.
Well, he keeps striking out on contestants. Let's go back to Judge Glazer because we're getting close to hangry time. So let's see what's up.
To wait to be promoted while everybody has discussions about my client is the functional equivalent of making me wait outside the courtroom. This is not your fault, Judge, but I've been sending emails, calling, sending text messages. As private attorneys, we should be able to be promoted as panelists to just be quiet till you call the case. But to be made to wait outside, I can't address any issues like right now. Go ahead.
Fine. Tell me off. It's okay. I'm going to recuse myself. You're going to have to get another judge to hear your case.
Judge, well, I don't. Judge, no. Did I say something wrong? Did I offend you?
Oh my God, please.
You're going to have to judge now because I'm not going to hear you.
Judge, I apologize if I offended you. I didn't say I wasn't attacking the court.
You are, sir. I do the best.
No. I was just whoever's in charge of the promotion is the issue I had.
That's
Judge,
me.
No, okay. Oh, I didn't know, Judge. I thought there was like a clerk or something.
I do the best I can here. When all these
Sorry, Judge.
interrupt me, it delays me even further. I have a 26-page calendar. I have a lot of attorneys, and I can't get them out of court. So
I wasn't aware it was you, Judge. And my deepest apologies.
I called you at the beginning of the calendar, and she wasn't here, sir. I did try, and then I have to do the ones that corrections brings in. I don't feel comfortable now hearing your client's case. We'll find another judge. We'll get somebody to come down. Okay? You find anybody who wants to come down. Sorry, ma'am. Okay, I'm sorry you have to wait longer, but next time.
Oh my God, I'm so sorry. Please, can you hear me out?
I want you to have a fair trial. I don't want you to have a fair.
Well, Judge, I just think there was a misunderstanding, Judge. I don't think there was. I've known you for 20 years. I don't have any issues with the court.
Please, Your Honor, I've been here. I'm a diabetic. I've been here since yesterday. They didn't have my insulin today. Please.
Are you okay if I do it?
I'm just asking for a standard bond. I don't know if we, like $5,000 between the two counts would be fine.
2023 case. Okay.
Yeah.
I'll do, if you have no objection to me proceeding, I will do it.
Of course, Judge. Of course. No, I have no issues. I just, I'm unfamiliar with, and I'm not here every day, so.
Speak to me privately and I'll tell you, you can sit here with me and see what goes on. Your wife was here earlier. I don't know if she left.
Yeah, no, and I'm a little bit frustrated myself, Judge, about the A-form issues. They're not letting us review A-forms, so I don't have the benefit of that. So it's a little bit of everything, Judge.
What happened now is that the clerk's office has to redact everything before they can be provided to the attorneys. You can email felonyfr@miami-dade.gov. All right, ma'am, you were arrested for grand theft, a second-degree felony, and contracting without or falsely advertising yourself as a licensed contractor. It's a case from October 23rd of 2023. You haven't seen the A-form?
I have not, Judge.
Says on October 23rd of 2023, the victim and defendant entered into a contract to remodel the victim's residence and fix building violations. The proposal was for $40,000 total. Defendant requested $20,000, which was provided by the victim in cash. On October 23rd, a second payment for $6,000 was given on November 10th, 2023. Deposit paid to defendant in total. The deposit paid to defendant was in the total amount of $26,000, and it provided the victim with a signed receipt for both payments. After receiving payments, defendant stated to the victim that the work would begin March 2024 and finish the work 1 week after starting. Since then, defendant never returned to begin the work agreed upon, and no money or supplies have been returned, leaving the victim at a loss of $26,000. So they reported this case to the Economic Crimes Resources on April 4th, 2025 for an investigation. The victim positively identified the defendant as the person involved in the case. She was located and taken into custody. Post Miranda, she provided investigators with a recorded statement stating she did pull permits, but that the victim did part of the job herself. Defendant continued to state that she offered the victim a refund, but it was refused by the victim. That's what's going on. Okay.
Okay, Judge. Thank you. All right. So, Judge, she's been here for 32 years. She has a minor son that she lives with. She's a sole provider for that child. She has a spouse. Her entire family's here.
What do you want?
I'm gonna ask for a reduced bond, Judge. I've also known her personally for 17 years or so. So, what's that, Judge?
Pretrial.
Oh, I would love pretrial. Yes.
Ma'am, you are ordered to stay away from Maribel Garcia, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from the victim, her home and school and place of employment at all times.
The judge, she's got a long history of theft and contracting without a license, probation violations, state's requesting a bond.
Nothing recent, though. These are all old. You're right. 2015 was the last one.
All right.
Okay. Anyway, I'm okay to give her pretrial. She's not a flight risk. She has an attorney representing her. I just want to see one thing. Where did it say she's not a contract? She falsely advertised herself.
This is the thing, Your Honor. Can I say something?
Okay. No. Hasty, please
No,
don't say it.
okay.
And Judge, we're gonna contest that because her spouse is a contractor. So this is gonna be the point of the issue in the case.
I don't see probable cause for count 2. It's just count 1. Anyway, right, Miss F?
Right.
And Judge, I want to just give my sincerest apologies to the court. I have the utmost respect and admiration for this court.
I have the utmost respect and admiration for you and your wife. How about?
Oh, that's really sweet. Thank you, Judge.
Anyway, that being said, pretrial services, alternate bond, 2,500 count 1, release outright count 2. So, ma'am, you have a good lawyer. Listen to what he tells you. Thank you, Mr. Travella. Have a good
Thank you, Judge.
Thank you. Okay, thank you.
Next. Let me tell him. Renee have his phone. Can you text him and tell him? Yeah, let him know we're good. All right, next we have, I know I have private lawyers waiting. I am trying hard to get you guys out of here. Mr. Reynoso's been waiting.
Do you know who Mr. Reynoso has, Your Honor? Because we have the ones that Ashley called us about earlier, so we have them lined up. So I don't know if you want me to call.
Orlando Pardo Ortega, Judge.
Got it, page 10. See, I need your help sometimes.
Number 34 on page.
Huh? I have it right here. Orlando Pardo Ortega, page 10. There's no stay around?
Good morning, Your Honor. May please the court attorney Walter Reynoso on his behalf. I'd advise the court that I have his wife present with me, as well as his daughter. His wife is Maria Nilda Garcia, and his daughter, ladies, Maria Pardo, are present with me.
First of all, I promoted you as a panelist if you want to turn on your camera. Sir, do you speak English? Good morning.
Señor, buen día. ¿Usted habla inglés?
No.
No.
Good morning, sir. You were arrested for a case from June 24th of 2025.
Buen día, señor. Usted fue arrestado por un caso que data del 24 de junio del 2025.
Charges organized scheme to defraud, 4 counts of grand theft, a third-degree felony.
Aquí tenemos acusaciones de haber estado en una confabulación o en la creación de una confabulación para estafa. Aquí tenemos 4 acusaciones de hurto en mayor cuantía, que son delitos mayores en tercer grado.
Theft of fuel with a modified vehicle fuel tank, 16 counts.
Además, tenemos 6 acusaciones de hurto de combustible a través de un depósito o tanque de combustible, 16 acusaciones de ello.
8 counts of fraudulent use of a credit card, over $100.
Tenemos el uso fraudulento de tarjeta de créditos por un exceso de $100.
And also one count of obtaining fuel fraudulently.
Y además una acusación de haber obtenido el combustible de manera fraudulenta.
So your attorney is here. Mr. Reynoso is here. Good morning.
Tenemos a su abogado presente, el señor Reynoso.
Mr. Reynoso, what did you want to say, sir?
Judge, I apologize. I just want to advise the court that I'm here on behalf of Mr. Orlando Pardo Ortega. Present with me in my office is his wife, Maria Nilda Garcia, and his daughter, ladies, Maria Pardo, for support, Judge.
Thank you.
Informa a su abogado que le acompañan su esposa y su hija, quienes están presentes en señal de apoyo.
Do you have any argument regarding probable cause?
I don't, Judge. I would just note that I'd ask for a $10,000 bond on the initial charge and an ROR on the rest of them. These are nonviolent charges, don't involve firearms or drugs. My client is not a flight risk. He's got family support. He owns property. He's a United States citizen.
Indica el abogado el abogado defensor que no tiene ningún argumento en cuanto a motivos fundados, sin embargo estaría solicitando una fianza de $10,000 en cuanto al cargo principal número 1 y los demás una liberación bajo palabra, dado que estas son acusaciones no violentas que no involucran armas de fuego ni estupefacientes o drogas, además que usted no representa un riesgo de huida ya que usted tiene su familia acá, tiene propiedades, es ciudadano de los Estados Unidos.
So Judge, in response, the vehicle the defendant's filling with gas, it's not safe. If you got into a car accident, they could potentially be an explosion.
Indica la fiscalía, su señoría, en respuesta diría yo que el vehículo que estaba utilizando el acusado no era un vehículo seguro para ese tipo de transporte. De haber tenido un accidente, probablemente hubiera causado una explosión.
We've also got the victim gas stations as well as the victims of the identity theft with the credit cards.
Además, también tenemos como víctimas a las gasolineras y además también la víctima del robo de identidad de la tarjeta de crédito.
So that he's involved in a sophisticated scheme to use fraudulent credit cards to steal diesel fuel.
Él está involucrado en una confabulación para estafar, involucrando el hurto de combustible diésel y además de tarjetas de crédito.
One of the transactions between April 24th and 25th, it was 16 transactions totaling over $2,600. And the credit cards came back to a country in Hong Kong.
Además, tenemos transacciones acá que datan de entre el 24 y 26 de abril, donde tenemos 16 transacciones, llevándonos a un total de casi $2,600. Y estas tarjetas de crédito fueron entonces, pues, puntualizadas a un país por allá por Hong Kong,
Probable cause.
una ciudad.
I don't know how much I'm going to reduce the bonds, Mr. Reynoso.
Motivo fundado determinado, señor Reynoso, no sé cuánto voy a estar reduciendo la fianza.
I understand. Well, count one, organized scheme to defraud is $2,500.
Cargo número 1, la confabulación organizada para estafar $2,500.
What do you want me to set for the grand theft charges? I think the stealing the fuel is more, I don't know, retail fuel theft is more appropriate. You want me to set, what do you want me to do? Set everything else at 1,000 each?
That would be fine, Judge.
Entonces se comprueba con el abogado si desearía que el resto de las acusaciones se establezcan en $1,000, ya que al parecer se reajustan más a hurto en menor cuantía o hurto de tiendas o de menor cantidad de combustible. El abogado está de acuerdo.
Are you okay with that? Counts 2 through 30 will be $1,000 each. That's fine.
Your Honor, for the interpreter, you say count 2 to
30, the grand theft, the retail theft of the fuel. I'm going to set all the rest of the counts at $1,000 each. Counts 2 through 30.
Thank you, Your Honor.
Muy bien, desde las acusaciones 2 hasta la 30 van a ser $1,000 de fianza que estarían teniendo por comprendido el hurto minoritario de este combustible.
Sure, you have a good attorney. Listen to what he tells you.
Tiene un buen abogado. Señor, por favor, escuche los consejos.
Judge, there's one remark on the from the docket. It says that he has a citation. I'm not sure if that's a criminal citation. I don't want that to hold him.
Corrections, does he have anything in misdemeanor court or traffic court?
No, that's part of this case, Your Honor. It's a ticket, but it's part of the felony.
Okay.
Does Your Honor have to set a bond on that?
Well,
what?
It says to be set, so it's going to be probably count 30.
Count 30?
The ticket is under the felony number, right? Corrections? There's no.
Yes, it's under the felony number. It's the ALRJ0XE, but it says something about fuel obtained fraudulently.
It charges you the second-degree felony. What do you want me to do? Leave it at 1,000, Ms. F?
Yes, Judge, that's fine.
So
I just didn't want something left out that would hold him.
He's good. Counts
Thank
two.
you, Your Honor.
Muy bien, se esclarece el último citatorio, también se establece $1,000 la fianza, su abogado comprueba de que ya haya tenido establecida la fianza en ese citatorio para que nada le retuviese.
Are there any more? Thank you, Mr. Reynoso. Are there any attorneys I did not call?
Thank you,
Please,
Your Honor. Have a good day.
so I can get your case for you. I see some, if there's any attorneys here, I didn't miss your case, let me know, because I got to go through my calendar. I haven't even started page 1, it's 11:25. Do you have, do I need Oscar Ceballos? Is a private attorney for that? What happened to that attorney?
Good morning, Your Honor.
Good morning, sir. Who's your lawyer?
I haven't been able to connect since I've got here, but I guess when I get out, I'm gonna have to get in contact with him and my mom, I guess.
Checked in, I think, for you. That's why it says somebody wrote private attorney here. Let me take a look. If there's an attorney, we missed him. Okay, somebody wrote Oscar Ceballos. I don't see an attorney.
We could start from page 1.
Well, he's here now. I'll do it. 1 minute. All right. This is Mr. Ceballos on page 13. Sir, you were arrested for aggravated battery, domestic battery by strangulation and battery. Can you afford to hire a lawyer, sir?
Pardon me?
Can you afford to pay for an attorney? You're 22?
It would, yeah, be me and my mom.
I'll appoint the public defender's office for you. So I don't know if there's a victim here. Is Gabrielle Amato here? Is the victim here? I don't know. It's a case from December 8th of 2024. Are you still together with your girlfriend, the alleged victim, Gabrielle Amato?
No, ma'am. She had. Oh, sorry.
All I needed to know for the stay away order. All right, let me review for probable cause. There's probable cause for count 2. I don't know if count 2 is a felony battery. I mean, count 1 is a felony battery.
That's a labral tear.
He wasn't intending to do that. All right, so sir, you are ordered to stay away from Gabrielle Amato, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. So do you understand the stay away order? You can't.
Yes, Your Honor.
I don't know, state. It has serious charges. It happened in December. Do you have
No,
money?
we just had a bond.
Do you have money to pay a bond? Otherwise, you can do house arrest.
Yes. I'm gonna pay it when I get back into the cell. I'll call my mom to pay it.
Okay. I think.
Pardon me?
Oh, that's fine. Count 1, I think it's probable cause for felony battery. I'll just split them all, I guess. Count 1 will be $2,500. Count 2, battery by strangulation, $1,500, and count 3, battery is $1,000. Good luck to you, sir. Have a good day.
Thank you, Your Honor.
Then I have.
All right, let's switch it up a little bit. Hopefully she gets her lunch soon. Let's go to... We'll go back to Judge Stevens.
All right.
Yes, Your Honor.
The defendant is present, and Ms. Holmes is present. His attorney, the state's attorney, and probation office official is present. The defendant has been on probation since 2022. I believe we placed you on deferred or unadjudicated probation January 27th. So that's about 3.5 years.
Yes, sir.
And you were placed on probation for 5 years. for the third-degree felony of assault family violence. The court has received a report and also has received a motion for early release from probation filed on behalf of the defendant by this attorney. And the court has also received a report from Mr. Hill from probation on this case. Have you seen this?
No, sir.
Yeah. Here is what I highlighted in yellow, which I think is the bullet point on all of that, where the position is going to be that the probation office is taking on. You have earned reward, but the probation office, from his standpoint, feels like termination at this point ought to be kind of put on hold, but you would be placed on inactive probation, weaning you off for a year, seeing how you do. And if all is well there, we would reconsider this, and it would be obviously likely that you would be then terminated from probation, and this case would be then dismissed. The inactive probation consists of just a couple of things you have to do, and he'll go over that with you, but you're not going to have to do all that. You're facing, what is it, 30 some odd?
He's completed everything.
Yeah, 30 some odd. I think there's you have 34 conditions, and really at the end of the day, what would he have to do in inactive? What would be his requirement? Just stay out of trouble, which is what we all have to do, and that goes without saying. But what are his affirmative obligations in an inactive probation?
Yes, sir. He's to commit no offense against this state, any other state.
I bet you he's going to follow that one.
Avoid injurious or vicious habits.
Okay, yeah, there. I mean, these are all things all of us have to really follow.
Avoid persons or places of disreputable or harmful character.
Run with a good crowd.
Work faithful at suitable employment.
Are you working somewhere?
No.
Okay.
Well,
You're trying to find out.
I had a job. I was working with Chevron on the third party company.
Yes, sir.
They changed some things within their ruling or whatever. And this came up, this case, about me being referred to the case, I guess the severity of the case. They had let me go because of this. And this is why I'm here today, to try to see if I can get off and complete so I can get back to what I do for a living.
Okay. We'll take it up. What else?
Support all his dependents, abstain from use or possession of any drugs, and never become intoxicated or under the influence of any intoxicating substance.
Okay. See, all of those are the conditions I have to follow too.
Yes, sir.
So there's no difference there. Now, on this job deal, and did you have a good relationship with the boss?
Yes, sir.
All right. Well, here's maybe the boss doesn't understand what inactive probation means and how that is different from active probation. That would seem to me to be a problem with a job.
It's the ISTC in the fleet. Okay.
So you can't have a pending charge. It's got to be, it's pending.
Yes, sir. And next would be a level 5, which in the state of Texas, that could be a level 2 to migrate to different plants in Texas.
Yeah. Okay. What we're going to do is Look, go ahead. Did you want to say anything?
Yeah,
I have a plan.
Okay.
But I want you to be heard in the state.
well, we are asking obviously that, we believe he's completed everything. He's been on for over 3 years at this point, on a 5-year deferred adjudicated probation, Your Honor. It is affected obviously with work. And so we are asking that if the court doesn't grant it today, that we not have to wait a whole year. So since he's obviously completed everything at this point.
Stay.
Your Honor, I spoke with Mr. Hill. I think he's also okay if he was terminated today. That was just a recommendation. I'd let him, speak to that. I think hearing this about the job issue, obviously would want defendant here to be working, Mr. Wallace. And I think he has, according to Mr. Hill, he's done well on his probation. I don't think we'd be opposed to termination, but obviously, I think Mr. Hill also said whatever the court.
I always buy into that, the weaning part of it.
Yes, sir.
I like that, the transition, but then again, it's specific to the individual and how they're doing. I mean, if they're doing well, reward the people. Would there be any objection if I followed the request of the defense and terminated the probation today and dismissed the case?
The only reason for my recommendation, Your Honor, is the assaulting nature of the offense.
Let me ask you about that. That's a good point here. The
I might think about 15 if you would.
What's the
Like was all it's in.
is this person's the complainant here still related to you?
Well, she's my ex-wife.
Ex-wife. Y'all have gotten a divorce?
Yes, sir. But we still.
Do you see her?
Yeah, I have. We still co-parent.
You have a child
We
or
have 2
two?
kids together.
You got 6 years.
We still co-parent.
How does that work?
Oh, it's better than ever. I mean, I had to do what I had to do, own up to what I did, and it's been great. I had to learn a lot of learning to do, a lot of growing to do, but.
What did you learn? Because this is, I've never choked anybody in my life. I can't even imagine because, it's brutal. Sometimes people lose their composure and lose their temper. But if you put your hands around somebody's neck and squeeze, there's only one intent there. I mean, that's to seriously injure or kill. And you don't do that to anyone unless you're defending yourself. Certainly someone you pledged love to. That doesn't make any sense at all. Because everybody's got good times and bad times in a relationship. We work through it without assault. Would you've been on this for longer than normal would be, but the criminal history kind of always finds people and that files you. That's why you want to avoid that. Criminal history, you got to carry that around your whole life. It wears you down. But it's a disturbing set of facts. But probation office feels as though you're worthy. Everybody else does, so the court will grant the motion for early release. I don't want to see you back in here.
Thank you for the class.
I know, everybody says that, but really own up to the promise. Because I see people back here in spite of what they say. You gotta walk the walk, not just talk the talk, right?
Yes, sir.
Put this into action. Be the best person you can be. Follow the rules. And remember, assault, when you assault like your spouse or ex-spouse, your children, what are they gonna do? You're role modeling all the time for your children, all the time. That's what a parent is. The example, the role model. What would you expect them to do when they lose their composure with someone? especially someone they pledge love to. You can't blame them if they start choking somebody. That you set the example. Fix that. You gotta always remember, it's not just your life on this planet. You brought people and children into this world, and you're responsible for the way they have become to a great degree. A parent is the most impressionable factor in a child's life. But you gotta act as though, I know you're nodding and you're saying it like this, but you gotta practice it every day. Okay. Anything else?
No, sir.
That is all. We'll,
The probation office will send it, email it to me and I'll get.
thank you, Mr. Gill. Thank you very much.
Thank you.
Let's see, Scott was.
Let's head up to Michigan and spend a little time with Judge Dad.
All right, people against Thomas, James Joseph Thomas, 22B141019, 24W726283. All right, your name, sir?
James Joseph Thomas.
Detective?
Morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Michael A. Carmen, P73824 on behalf of the defendant, Your Honor.
All right. I think the first thing I'd like to do is look at take this UDAA case. So, and then I'll come back to the misdemeanor that he absconded on. So for purposes of arraignment on the UDAA, how does he wish to proceed?
Your Honor, he'll stand mute, waive the formal reading.
Okay, Mr. Thomas, I'm going to advise you of your rights, sir. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the questioning with law enforcement, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss the case with the prosecutor, see if they can reach a resolution. If it does not resolve at that stage, you have the right to a preliminary exam, at which time the people have to show that the crime was committed of UDAA and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, sir.
All right, so probable cause conference will be July 8 at 9:15. That's in front of Judge Hessen. Preliminary exam will be July 15 at 11 a.m. That is in front of Judge Hessen. So we can address bond on that. But let me, before I do that, I'm going to go on to this other file, 22B141019. Mr. Carmen, your appearance.
Michael A. Carmen, P73824 on behalf of the defendant, Your Honor.
Sir, your name?
James Joseph Thomas.
I placed you on probation in June of 22, June 22nd. I think, let's see. And then you just didn't show up anymore. I told you to acquire test results from a doctor on March 13 of 23. And then I said I wanted your mental health records and I wanted to review April 11 of 2023. You were to get both of those things. And you didn't show up. Why didn't he show up? That was April 11 of 23. I issued a warrant.
Back then, I had a problem with substance abuse. I was going back and forth to the addiction, fighting it, trying to get better or whatever. And I had the wrong mental health, and I had different things playing against me or whatever. But I've been clean since October 3rd. I've been to the doctor once a week, taking a drug test in Wayne. I live in Wayne in an apartment. I got a job. I've had a job since around the same time, since around December. So right after I got clean, I went to treatment at Sobriety House, and Salvation Army. My peer recovery coach is in the courtroom. I just seen her walk in. I got clean time now. I go to NA program. I'm in the NA program. I just went to the camp out. I go to meetings every day. I got a coffee position. I'm a hugger and greeter chair from a Dirkman. Like I'm getting involved.
Slow down. Just slow down. Is he employed, Mr. Carmen?
Your Honor, he is.
Yeah.
He works full-time at, I believe it's Simply Break Construction, full-time, earns about $500 a week.
Do you work 40 hours, sir?
Yes, I do now.
All right. And what exact date did you get clean?
October 3rd.
Of 24?
Of 24, yes.
Why didn't you show up since then?
I just haven't, I haven't dealt with it. I know I needed to deal with it. You try to get my probation reinstated and fix the legal problems, but I just started with the program and I just been working to stay clean. It's been really hard to stay clean, but I'm there. I mean, I'm doing what I'm supposed to do. And I'm with Pure Psychology, getting mental health, and I'm with a doctor, addictionologist in Wayne, getting help. And I also reside in Wayne. And then I have a peer recovery coach.
Slow down. What is your new address?
32652 Bluebird Lane, Wayne, Michigan, 48184. I've been there a year.
Detective, was he notified on this other case to show up? The warrant was issued in 24 as well. The UDA. Slow down. I'm talking to the detective. Okay, just let me. Do you know if anybody? Go ahead.
I don't, Your Honor. I believe it's a Woodhaven case, it's not ours.
Oh, that's
I don't
right.
know if I or not, but I would say that his address with Secretary of State hasn't been updated in a few years, so that could be why they might have sent notification to the wrong address.
Yeah, I was never notified.
All right.
But I will come.
Sure.
Probation.
Honestly, you've really gone out of your way to not cooperate here. Okay, so you're not going to get a person. Listen, I'm going to get you an early date. I'll be fair with you, but you've proven to me you don't like to show up.
Can I do it?
Sir, I heard everything I need to hear here. Please. 6,010% on 22B141019. Lisa, I'd like to, is this going to be, can we do this tomorrow? Do you think? Let me just check something.
Do it tomorrow or July 8th?
I don't want to keep him in that long. Even I want to be a lot more fair with him than he's been with us. But I do want to, I almost need an updated screening. This is so old. Sir,
Good job.
sir, you keep interrupting me. I'm trying to be patient with you. I really was asking your lawyer to talk, not you, and you're going on. I'm just going to ask you to refrain. Will you do that for me, please?
Yes, sir.
So I'm going to keep him, I'm not going to keep him in that long. We'll do tomorrow, and we'll do that at 8:30. Can I do it at 8:30? No, I don't need to do it at 8:30. That's fine. We'll make it at 11. And then they can do an updated screening today, okay? Updated screening and assessment today, probation can. So if you do post this money, you're going to have to come in here and be screened and assessed today. If you don't post it today, then you're going to be in custody until then. And let me just check one other thing here. You also have other warrants. You're aware of that, right? So
Yes,
I'm not the only one you don't show up in front of. You've got a habit of doing this. 10,010% on this on the felony. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No contact with the victim or with prosecution witnesses except through your lawyer. Again, you cannot violate a law. You must appear in court as directed on that one, starting on July the 8th at 9:15. You're making matters worse by not showing up. Do you understand that?
Yes.
So if you post the 600, nobody here is going to be unfair with you, but you need to show up in court and stop acting like a fugitive. June 26th at 11 is the sentence, updated PSI screening. So we're going to have probation get a hold of him over there. There's no reason for you guys to come over here with him. And then July 8th at 9:15, you'll be in front of Judge Nelson. Any questions, sir?
No, sir. That's it. Is the bond only 600 to bond out is what you're saying?
600 on one case, 1,000 on the other.
All right, thank you.
Thank you, Your Honor.
Thank you. And Crystal Holt, Crystal Marie Holt, 25W838286.
Good morning, Your Honor. Josh West Green on behalf of the people.
Good morning.
Mark Hyder on behalf.
Nice suit, Mr. Hyder.
Your Honor, thank you.
You look awful sharp there. Ms. Holt, your name?
Crystal Marie Holt.
All right, so I capped the cost of recovery. I see that they've got $375, but on a blood draw, just so, this is newer to Woodhaven, right?
Yes.
I cap it at 220 on a blood draw and 225 on a blood draw, 150 on a breath test. So this is going to be a plea to impaired with the super drunk to be dismissed, right?
Yes, Your Honor. I just want to put on the record, I did contact both victims of this matter. One called me back, and there is no restitution for him. He was the driver of the Ford Escape that she hit. Her insurance covered his damages, so the only restitution will be the $100 to the car wash for the surveillance camera.
Oh, okay. All right. I want to make sure we get that on here. So $100 to car wash for restitution?
Yes, Your Honor.
All right. I still am going to notify them, I have to, right, of their right to appear. Ma'am, do you understand what your lawyer has worked out? This is what it is, right, Mr. Hyder? Impaired driving, super drunk to be dismissed. You did a great job. So we got a 6-month reduced to a 93-day. You would have had to lose your license. If that was super drunk here, you're going to have it restricted from day one, and it'll be a 90-day suspension. Do you understand that?
Yes.
It is punishable. These are just the maximums, up to 300 fines, 93 days jail, 360 hours community service. Court costs are all those 4 points. License suspension or revocation in accordance with your record and your vehicle could be, or I might have to be immobilized depending upon your record. Do you understand that?
Yes.
And again, you did sign and read and understand an advice of rights form here today, correct?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
All right, to the charge operating while visibly impaired, how do you plead?
Guilty.
On April 17 at 25 at 4:25 p.m., were you operating a motor vehicle at the Whitewater Car Wash in Woodhaven at or near 20981 West Road?
Yes, sir.
What happened?
I backed up into someone.
Because you were going through the car wash?
Yes, and I didn't drive onto the conveyor belt correctly, so he told me I had to back up and there was something behind.
I see. Had you consumed alcohol prior to that? And if so, what and how much?
It was tequila, about 4 or 5 shots.
And what else?
That's it.
How big were the shots?
750, I think there.
Well, I didn't ask you how much you paid for them. I just want to know how. They were not regular shots, right?
They're the ones
You got your fingers about 2.5 inches apart, so it wasn't just a normal, really small shot, right?
No, the ones you buy at the liquor store.
Okay. And so do you think you backed up into this vehicle, at least in part because of your alcohol consumption?
Yes, sir.
And also, Mr. Hyder, they took a blood draw and the blood draw results indicated she had a .244, correct?
Correct.
Are you on probation or parole, ma'am?
No, sir.
Anybody forced you to plead guilty?
No, sir.
She ever been in trouble before?
No.
I'll accept your plea. I am concerned about the the blood draw though, ma'am. I want you actually, look, I'm not
There
gonna.
is an explanation. It's kind of a one-off. She was at the casino. She works in Toledo. She works for Jeep. She's got a good job. She got lucky at the casino and
Had a little too much.
had a little too much. It's
A lot of
very
too much.
much.
Where were you drinking at?
The casino and on the way back.
All right. Look,
She showed me it.
Nice, nice. All right, ma'am, I have to have you still go AA 3 times a week. I'll reconsider it sentence. AA, NA 3 times a week, no alcohol, no marijuana, no illegal drugs, no contact with the victims or prosecution witnesses. You cannot, do you always, you work in Ohio, right? You live in Woodhaven?
Yes, sir.
Can leave state for employment purposes without consent, okay?
Your Honor, she also has a vacation coming up July 15th to 20th.
And where's she going? Florida?
Yes.
I'm sorry, I missed the last part. Can leave to go to Florida July 15th to
20th.
to 20th. Where are you going in Florida?
All of Myrtle Beach, South Beach, Miami. Myrtle Beach is South Carolina. I'm nervous.
What? You going to South Carolina too? If you are, it's not a problem.
No, just Florida.
That's gonna be
Fort
hot.
Lauderdale
Fort Lauderdale.
and Miami.
It's gonna be hot.
Hopefully.
All right, that's what I'll do. We'll give you a date. Lisa, give me a date for her.
July 23rd at 8:30.
I'm sorry?
July 23rd at 8:30.
That good with you, Mr. Hyder?
Yes, you need. Yeah, that's a good day, Judge.
July 23rd at 8:30 will be the sentence date. And give her an AA form, John, if you didn't. And that has to be, you have to go in person for that. I am concerned about this, all kidding aside. You're over three times the legal limit here.
Yes.
Okay?
Yes, sir.
I mean, seriously, there's Ubers, there's cabs. Maybe you should have just spent the night there, you know what I mean?
Yes.
Good luck to you. We'll see you July 23rd. Mr. Hyder, nice to see you.
Nice to see you, Judge. Thank
Good
you.
luck, ma'am.
Thank you. Where do you want her to go right now?
She's gonna go down the hall, get her notice,
Okay.
and then you're gonna go over to probation where you'll fill out a questionnaire and be interviewed.
Okay.
Okay? Good luck. Do you have 1 second off, and nothing to do with this?
Yeah.
Come on in.
All right, well, he steps away. Let's go back to Judge Stevens.
Are charged, ma'am, in 2 cases, 19-32373 and 32374. These 2 indictments. Good Lord, were ended up in 2019?
Yes, sir.
Wow. That's 6 years ago. Have you been living in the same place for the last 6 years?
Stayed in Houston.
Yeah. Okay, well, 2 million people. It's hard to find somebody if we don't know where you are. It's when you're in with 2 million people.
I was arrested for this in 2016, so I didn't actually know about the indictment.
No. You were arrested for this when?
In 2016.
No, you weren't. This says you committed this offense on May 25th, 2019.
Well, sir, I was indicted.
This, ma'am, the indictment from the grand jury states this happened on or about May 25th, 2019. You can shake your head all day long, but it's not a debate. That's what the grand jury. I'm looking at the probable cause affidavit as well. This states on 5/25/2019. This is signed by the police officer who did this and sworn to on May 29th, 2019. There's nothing, you're wrong.
She was arrested for this type of offense in September 2016 for a separate charge at Harris County, Judge.
Okay. Well, this has nothing to do with Harris County. This has everything to do with Houston Avenue in Port Arthur on 2019. This is 2 cases here charging you with the 2nd-degree felonies of assault on a peace officer. In each of these cases, alleged to have occurred on or about May 25th, 2019 in Jefferson County, Texas. It is alleged you bit the officers in each case, which wasn't a wise thing if that was true. So in each of these cases, if convicted, you are looking at no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 can be assessed. So your punishment range is up to 40 years confinement in prison on each of these two cases. Together, do you understand?
Yes, sir.
All right. Are you employed somewhere?
Yes, sir.
All right. Are you getting a lawyer?
I'm gonna.
You gotta have a lawyer. And if you're working, I expect you to hire your own lawyer, and that's what people have to do. If they're in a mess, you have to fix it. You're responsible to helping yourself.
Yeah.
Where are you working?
I work at Luby's in Houston, Texas.
I know this one. Um, at Luby's?
Yes, sir.
Oh, let me just ask one question. Those chicken fried steaks and those fish, what's in that batter that makes it so good? No, I don't want you to, that's a secret. But I love that food. So how much, what do you get paid?
$12 an hour.
Ma'am?
$12 an hour.
That ends up being about 25,000 a year. It's going to cost you more than this for a lawyer. I want you to fill out, you're going to sit over there and fill out one of those indigent forms, and we might be able to get somebody. And Mr. Dusler is here, he's one of our public defenders. We might be able to get him to talk to you about this. First of all, this is this is very unusual. You never have cases that come in here 6 years old. When the rare event that we do, we have to move them along because they're too old right now. But that's what happens when you're in another city and you must have moved around. I've got 1755 Crescent Plaza as your address.
I haven't lived there.
See, I need to know. Stand by. I'm going to mute this for a second. Okay. I've got your correct address. I can figure this out here. I can find this out, but I'm going to ask you to help me right now. What is your criminal history?
I have a previous assault that was reduced to misdemeanor. I did 30
Where?
days, Harris County.
That one she was mentioning from 2016.
Is that it?
Yeah.
That's all?
And then I have something from when I was 17, in Mecklenburg County in North Carolina. I was in like juvenile jail in North Carolina.
They treated you as a juvenile, not as an adult?
Yeah, as a juvenile.
You sure?
Yes.
Because it will be found that if we can do the criminal history. I just
They did.
trying to think of, so you don't have a felony conviction?
No, sir.
Fill out a indigent form we're gonna get that for you. And fill that out and we'll review it. You swear to it. And then if I find it worthy, then we're gonna appoint you a lawyer to talk to you immediately, okay? Oh, and, Mr. Childress, come on up. You're, clear. Did you get a resetting?
Not yet.
You need to get a resetting.
And Judge, that's gonna go on trial docket and he's asking I be relieved.
Well, give, all right, he's not eligible for probation.
No, sir.
Sorry. What was the offer on it?
12 years.
All right. You understand, sir, you're looking at up to 20 years in prison on this. You understand? Okay. All right. And we're going to set it for a trial. That's what you want. There are no deals. Today's the day. That's it. We're going to move forward. We're going to move forward and, we're going to set it for trial and I'm not accepting that this is the time to negotiate the deal. So you passed that one. So, Mr. Dusler, he's a fine lawyer. He can try it. It'd probably get to trial quicker if you agree to release him. The next person on the trial docket wheel would be representing you. Is that what you want? That's the way it would go faster. If you want it to get to trial quicker, then I find good cause to relieve Mr. Dusler and the next person on the trial docket wheel, who are all qualified lawyers, will handle the case. And we're going to note this. This was the time to hold on for just a second.
Let's go back to Judge Glazer because it's noon over there, so it's lunchtime and she's still going. That's concerning.
So is $7,500.
Voy a establecer una fianza. El cargo número 1, tirar un misil mortífero, $7,500.
Count 2, there's no probable cause, release outright, and count 3, battery of $1,000.
El cargo número 2, no existe la causa probable, por lo menos de la manera que aparece ahora. Y el cargo número 3, la fianza va a ser, I'm sorry, Your Honor, it was $1,000 for count 3?
Yeah.
$1,000 por el cargo número 3. La ignición.
Next, we have Stanley Nicholas, page 7. Only 19 pages, was it 7? Yeah, 19 pages to go. I'm keeping track. We're on page 7, it's 26. Yeah. Good morning, Mr. Nicholas. You were arrested for carrying a concealed firearm. I will appoint the public defender's office for you. You're out on felony bond. There's a hold for you to see your judge tomorrow for F24 5714. So he's 20. Let's see if the gun's concealed.
I think there may be a possession issue here. Yeah, because the gun wasn't.
There was a loaded concealed firearm wedged in between the seat cushion and the plastic lining for the vehicle. It was directly under within his immediate
car, and I just came.
It was concealed. There's probable cause. He's under 21 and can't have a concealed firearm.
Apologies. My understanding is he wasn't the only person in the vehicle. He was a passenger. There were other. He wasn't the driver.
Yes, I wasn't even a driver.
I don't see him being connected to that gun.
I just got in the vehicle to
Movement inside the vehicle from the defendant towards the bottom back passenger seat. And that's where they found the gun. There's probable cause. Anyway, it's a $2,500 bond. You'll see your judge tomorrow. Have a nice day, sir.
Oh, 2,500. I gotta wait till tomorrow.
Got to see if the judge, she may not let you post the bond. She may hold you on your open case. Next is Eddie Jones, page 7.
Pat?
Okay, good morning, Mr. Jones. You were arrested for possession of cocaine. I will appoint the public defender's office for you. Tap alternate bond. $1,000. You have an address, sir, where you live?
Ma'am.
All right, make sure to keep all future court dates. Have a nice day.
Okay.
Thank you. Next is Adler Montpierre.
He's a bond out.
Thank you. Thank you to the hardworking bondsman. Julio Figueroa, Julio Figueredo Lucia. Good morning, sir. You were arrested for 1 count of child abuse. I will appoint the public defender's office for you. Actually, can you afford to hire a lawyer? I see you live over in Sunny Isles Beach. Are you able to afford it?
Do you speak Spanish only? Spanish only. We need the Spanish interpreter, Your Honor.
Yeah, good morning, sir. You were arrested for child abuse. Can you afford to hire a private lawyer?
Buenos días, señor. Usted fue arrestado para abuso de niños. ¿Puede usted pagar un abogado privado?
No.
No.
I will appoint the public defender's office for you.
Voy a nombrar al abogado público para defensa de usted.
There's probable cause
¿Existe la causa probable
for child abuse.
para abuso de menores?
¿Está preguntando?
Are you asking me?
No, I'm telling you, there's probable cause for child abuse. You grabbed the child around, wrapped your arms around him to restrain him.
Because I tried to do
No, estoy diciendo a usted que existe la causa probable. Usted agarró a un niño, usted puso la mano alrededor de su cuello, el brazo alrededor de su cuello.
In order to stay away from the child whose initials are CG,
Estoy emitiendo una orden que usted tiene que mantenerse alejado del niño cuyos iniciales son CD.
no contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No debe tener ningún contacto con la víctima o directo o indirectamente o en persona o por escrito, por llamadas telefónicas o a través de terceras partes.
You must stay at least 500 feet away from his home and school and any place of employment at all times.
Usted tiene que mantenerse por lo menos 500 pies alejados de su casa, su escuela o su trabajo.
All right, I'll give him pre-trial. He's working and I guess he's unhappy. The boy keeps throwing his cast net over the pier.
Entonces le voy a dar servicios antes del juicio. Él está trabajando y parece que está infeliz porque el niño sigue tirando la cosa para buscar los peces en el mar.
Pre-trial alternate bond, $3,000. Have a nice day.
Servicios antes del juicio, fianza alternativa, $3,000. Que tenga buen día.
Next up, Andrew McCann on page 8.
Looks like one of the search warrants at a smoke shop.
One of those again. Good morning, sir.
Good day, Your Honor.
Arrested for armed possession with intent to sell cannabis and possession of over 20 grams of cannabis. I will appoint the public defender's office for you. I guess there's probable cause for the charges. He had a lot of dough on him, over $10,000. All right, you got money to post the bond? Do you have any money to post the bond? Yes, no.
No, Your Honor. We would be asking for pretrial services.
All right, pretrial services, alternate bond, count 1, armed possession with intent to sell cannabis will be $2,500, and count 2, possession of over 20 grams of cannabis. If it doesn't says over 20 grams, it doesn't say how much. I'll set count 2 at $500. Have a nice day.
Okay. Count 1 was what, Your Honor?
Pretrial alternate 2,500, count 1, 500, count 2.
Okay, thank you.
Next is Shavaj Dixon, page 8. God, I'm not going to finish.
Seems like they're missing a defendant. I will keep an eye on that court. I still have concerns. Oh, no. All right, let's watch this guy real quick because he's in the turtle suit.
You were arrested for petty theft, criminal mischief over $1,000, petty theft and resisting an officer without violence. You're on probation, so there's a hold for F14-237-83A. I will appoint the public defender's office for you. So he damaged the rear passenger of the police vehicle and will cost approximately $1,000. So I'm not sure it's a felony. Sir, you are ordered to stay away from the public supermarket at 12855 Northeast 6th Avenue in North Miami, Florida. You are not allowed to go to that store and you must stay away from there, sir. Do you understand?
Yes, sir.
All right. So I'm setting up on count 1, criminal mischief. State, what do you want on that? 500? $1,000, count 1, count 2, petty theft. It's count 2, petty theft is $100, and count 3, resisting without is $500. Have a nice day, sir.
You got a hold?
All right, now let's change it up. Let's go to Kansas because it's been a while since I've been there, and let's see what's going on with Judge Webster. She's often fun.
For date, please.
All right. Well, thank you for erring on the side of caution. Mr. Click, you are charged, since this is your first appearance, as your counsel says. You're charged in count 1 with improper driving on a laned roadway. Count 2, following another vehicle too closely, and count 3, improper passing on a roadway. Those are all infractions, all scheduled fines, no jail time. I have no doubt your attorney has told you all of this. Your request for continuance will be granted. Any objection to that, Mr. Regier?
Not under these circumstances, Your Honor.
Unfortunately, I do not have another opening until September 8th, which would be Monday at 9. I could fit it on a Wednesday, which would be September 24th at 9. Ms. Schmidler, any preference?
Your Honor, the September 8th at 9 o'clock should be just fine. Thank you.
Very well, you're welcome. This matter, Mr. Click, you and counsel will need to return September 8th at 9 a.m. And because that is set out so very far into the future, hopefully any resolutions between parties will be reached and presented at that time.
Yes, Your Honor. Thank you.
You're welcome. Anything further from either party?
Not from defense.
Not from the state, Your Honor.
Thank you. Ms. Schmidler and Mr. Click are excused at this time. Who else do we have? Do we have any other attorneys besides Mr. Regier? Any defense attorneys? Do we have anyone else at the Sallyport? Deputy Caulfield?
Yes, we do. Christian Garike. Christian. Take your head off and come on in.
Thank you. We are on the record in 2024 TR 3042, State of Kansas versus Christian Dakota Gawerke. Jared Regier for the state, the defendant appearing in person and pro se on count 1, attempted operation of a motor vehicle without a valid license, but Mr. Regier, is the state actually alleging that he did drive without a valid license?
Your Honor, I am reviewing the information that was filed with the court on November 18th, 2024. That same information would not appear to make any mention of any attempted offenses insofar as counts 1 or 2 are concerned.
All right, so we're looking at attempted, strike that. We are looking at driving without a license, no proof of liability insurance. It looks like you were here, sir, March 5th, and you were going to apply for diversion. Did you do that?
Yes, ma'am.
Were you granted diversion?
Honestly, I just did it a couple days ago, so I haven't got back the response. I just got the confirmation number, but I'm waiting on an email.
Did you hear me on March 5th tell you not to wait until the last minute to apply?
Yes, Your Honor.
But you did apply at the last minute, basically.
Yes, Your Honor.
Did you hear me tell you to go out and post a bond and get your picture and prints taken?
Yes, Your Honor.
And you did do that, didn't you?
Yes, Your Honor.
Well, I'm not going to grant you a continuance to apply for diversion. I'm going to set this for trial, and you will either, that'll buy you some time to get your diversion, but you'll either, if you don't have diversion, we're going to go to bench trial August 27 at 1:30.
Okay.
So be ready for bench trial August 27 at 1:30, or be diverted, but I'm not going to grant you any continuances for diversion because I told you to get that done and you've had several months to do it.
Okay, and then, sorry, Your Honor. I looked into some attorneys, but they were kind of pricey. I applied for a court-appointed attorney. Is that still possible?
Well, if you are applying for a court-appointed attorney, you probably should have talked to the attorney before you applied for diversion, because they usually like to participate in planning your defense. And you may have already made some admissions on that diversion and agreed to stipulated facts.
And Your Honor,
Mr. Revere?
not to interject, but notwithstanding the statements of the defendant on the record here today, I do not have any notes to suggest, in fact, a diversion application has been received by my office at this time.
Okay, Mr. Gorecki, what's happening here? Did you apply or didn't you?
For a diversion?
Right,
Yes, I applied a couple days ago
a couple days ago. Did you apply in person or online?
online.
Well, you literally held this off to the last minute. Well, a couple. You didn't wait till yesterday. But they don't have it.
Okay, so what could we do from here? Is it
Well, I would reemphasize that you can apply for court-appointed attorney. Again, you should do these things at first appearance and not delay 3 months into it to think about it. But I just need to know from you, are you applying for diversion? Or are you applying for an attorney? Which are you doing?
I would actually like to apply for the attorney.
All right. So you haven't applied for diversion, you're not going to, or you have applied for diversion, but you still want to apply for an attorney?
Yes, ma'am. I've applied for diversion, but I still want to apply for an attorney.
All right, well, you fill out an application and give it back to the officer.
Which he
And
did, Judge.
he did, all right. Where do you work?
Road safe traffic systems.
Road safe? What do they pay you per month?
Around 4,000 a month.
Well, I seriously doubt at 4,000 a month, you're going to qualify as indigent, that you're going to qualify for poverty level, but who knows? Go ahead and I'll look at that later. But in the meantime, we're set for trial August 27th at 1:30. If you qualify for an attorney, you're ordered to get a hold of that attorney and get set up for trial. He'll need to be ready for trial. Apparently, you're torn between whether you want the case dismissed through diversion or whether you want to take it to trial, but you can't do both. It's called a pre-trial diversion. It diverts you away from trial, but you can talk to your attorney about that, and he can explain all of that if you qualify. If you don't qualify at $4,000 a month, you're going to have to hire your own attorney.
Yes, Your Honor.
And you will be continued on your bond, and this time will count against you for speedy trial purposes. We'll be in recess. You may go.
Thank
Your
you.
Honor,
Yes.
I apologize. Just, I'll need a notice of corrections in order to change the charge from attempted to just what Mr. Aguirre had stated on the record.
Does that attempt come from the officer that enters it or from the county attorney that enters it?
It depends sometimes, Your Honor. It looks like this one was filed by the county attorney's office and just whoever clicked on the charge had clicked on attempted when they put it in. But on the information, they had still just put in the operating a motor vehicle without a valid license. So I just have to have a notice of corrections as a paper trail.
All right, if you'd make a note of that, Mr. Regier.
Very good, Your Honor.
Thank you. All right, we'll be in recess. You may go, sir. Thank you. You're muted, Deputy.
Next one I have is Sherry Teamstra.
That's right.
Okay, we are on the record in 25 TR 387, State of Kansas versus Sherry Marie Teamstra, Jared Regier for the state, defendant in person. Ms. Teamster, you're charged with one count of improper driving on a laned roadway, an infraction. This carries a fine and court costs if you were to be convicted, but no jail time. And you have asked that we set this, so you are wanting a trial, is that correct?
Well, I guess so. I thought that this was kind of that. I was following the procedures at the school for carpool pickup, and it requires you to cross a double line. And so I did cross a double line, but it's because it's the carpool pickup line.
All right,
So-
well, we will set this for trial. And the next trial will be August 20th at 1:30. You'll need to be back here with any witnesses or evidence you intend to present. August 20th at 1:30. I don't know if you qualify for or are interested in the county attorney's diversion, but that information would be available at bucoks.com.
I looked that up. I heard you mention it to someone else, so I looked it up. Does that means you pay an additional fine, but then you don't have to go to trial and it doesn't affect my insurance? Is that correct?
It means that, yes, you have to pay your fine, your court costs, and an additional diversion fee. But if you qualify and do what you're supposed to, then they dismiss it and know it couldn't be used against you for any other purposes.
So do you think that I should go to trial or do the diversion?
That is not appropriate for me to say. That's
Okay.
your decision to make.
Okay.
And I can't appoint an attorney, but you can always talk to an attorney of your own accord.
Yeah. Okay. Thank you.
All right. You're welcome. Thank you. We'll be in recess on Ms. Teamstra. We'll take up Justin Corbin while we're waiting on security. We'll be on the record in 2024 TR 3051, State of Kansas versus Justin Allen Corbin. Jared Regier appears for the state. Mr. Corbin appears in person and pro se. So give me just a moment. Mr. Corbin, this is your first appearance on this case. In count one, you're accused of driving while suspended after a prior conviction for driving while suspended. That prior conviction would elevate this to a Class A non-person misdemeanor. That means if you were to be convicted, there would be a mandatory must serve 5 days minimum in county jail. But your sentence could be up to 1 year and your fine could be up to $2,500. On count two, you're accused of driving without proof of insurance. This would be a Class B misdemeanor. If convicted, your fine could be anywhere from $300 to $1,000. You could have it a 6-month sentence. On count three, you're accused of operating a motor vehicle without lawful registration or with expired tag. This is an unclassified misdemeanor. If convicted, your fine could be up to $2,500 and your sentence could be anywhere from 30 days to 6 months. Do you wish to hire an attorney, apply for court appointed, or waive your right and represent yourself, Mr. Corbin? Okay, you're kind of cutting in and out, so I didn't hear what you said. You're wanting to apply, did you say? We are just not hearing you at all, Mr. Corbin.
Sorry, I've got it unmuted. Can you hear me?
Well, you're still cutting out, but I'm at least hearing you. Are you wanting to apply for an attorney or hire an attorney or waive your right to attorney?
I'm going to hire.
Well, I am just not hearing you. Is there any chance you could, I don't know, sometimes if you step outside, are you on a computer or a cell phone? Your phone? Do you think if you stepped to a different location, you might not have as much interference? I'm going to need you. Okay, I'm going to need to either have you go to another location and call back where maybe you have better reception. You could even go to the courthouse in El Dorado. I don't know how long it would take you to get there, but at least I'm going to have enough connection that I can communicate with you. For some reason, it's just not working.
Can you hear me now?
No, it is just too staticky. Why don't you try to call back? Missy, do you have any other suggestions?
You can try that first, the calling back to see if it's just a bad connection. Otherwise, it would be the service.
Which means?
The like if he's on Wi-Fi or just the data.
Okay, he'd have to go somewhere else.
Somewhere else, yes.
Okay. All right. So you can, as she just said, if you can hear us. Can you hear us okay, Mr. Corbin? Or are we all cutting choppy too? Okay. Well, try to call back. I'm gonna recess your case right now and let you try to get your signal better because this isn't gonna work for us. We'll be in recess. And then deputy, do we have anybody else in court security?
No, we do not.
Really? Wow, that surprises me. Well, let's move on then. Let's take up Dexter Adams on the record in 2025, TR 558, State of Kansas versus Dexter Adams. Jared Regier for the state. Dexter Adams, are you here? Dexter Adams was to appear on a citation and uniform notice to appear. And charges of defective tail lamp, driving while license was suspended. The citation that was given to him personally told him to be here today at 9 a.m. Mr. Regier, recommendations?
Your Honor, in this matter, the state is requesting a bench warrant, 1,000 cash or surety. This is a case where my office did file an amended information on May 13th of this year. I do not know if the court is aware of it, but that same amended information would appear to dismiss count 1 while retaining count 2, driving while suspended, a Class B misdemeanor.
Very well, a bench warrant is issued, bond is set at 10,000 cash or surety.
Forgive me, Your Honor, the state's request is 1,000 cash or surety.
I thought that's what I said. It's certainly what I meant. So it is 1,000 cash or surety.
Thank you, Your Honor.
You're welcome. We'll now take Danielle Tucker on the record in 2025 TR 590. State of Kansas versus Danielle Leanne Tucker. Chair Regier for the state. Ms. Tucker appearing in person and pro se. Can you hear me, Ms. Tucker?
Yes, ma'am.
Thank you. This is your first appearance, and in count 1, you're charged with improper stop or turn signal. That is an infraction that carries a fine only of $75 and 108 court costs, no jail time. Count 2 charges. Let's see, you have an amended complaint, so let me look at this. Count 1, improper stop lane, was dismissed on May 15th of 2025 by the state. Count 2, no driver's license in possession, was dismissed by the state. So you're looking at count 3, driving on March 18th, 2025 in Butler County, Kansas with no proof of insurance. This is a Class B non-person misdemeanor. The fine can be anywhere from at least $300 to $1,000, and the sentence could be up to 6 months. Let's see. You may be able to qualify for the county attorney's diversion program. Have you been hearing me talk about that?
Yes, ma'am.
And do you want to look into that?
Yes, ma'am.
Because if you can get proof that you have insurance now and follow their requirements, you may be able to get this dismissed and off your record.
Okay.
I will. Now, I'm not gonna play around. If you want diversion, you get in there and you get diversion. Don't delay like you've seen others do.
Of course.
I'll set this for controlled docket September 18, but that gives you plenty of time to get that dismissed and off the docket.
Okay.
So September 18th at, I'm sorry, let's make that, I don't know where I picked that date. Let's go with September 24th at 9. No, yeah, that's what we want, isn't it, Destiny?
It is, Your Honor. I was gonna ask you just to make sure.
Yeah, it's like, what am I doing here? September 24th, 9 a.m. Now, if you're diverted, you won't have to be back here. And if you come back and you should have been diverted, I'll be cranky because you didn't get it done by then. Okay, now then you also may need to get your picture and prints taken. Let's look at that. Yes, it's a B misdemeanor. So please go into a breakout room when it flashes on your screen with court security too. The bond will be 1,000 OR. You won't have to put that money up. unless you fail to come to court, but you do need to go out and get those pictures and prints done right away.
Of course.
All right. Anything further, Mr. Regier?
No, Your Honor.
Very well. We'll be in recess on Tucker, and she'll need to go into the breakout room. Thank you, Ms. Tucker. Let's take up Jordan Vaughn. We'll be on the record now in 2025 TR 531, State of Kansas versus Jordan Lynn Vaughn. Jared Regier for the state. Defendant Ms. Vaughn appears in person and pro se. Can you hear me, Ms. Vaughn?
Yes, I can hear you.
Thank you. You are here for first appearance.
Yes.
You were issued a citation, but it looks like this county attorney. No, you didn't file an information, did you, Mr. Regier, or an amendment?
The state is not aware of any amended charging documents in this file, Your Honor.
Very well. So, Ms. Vaughn, in count one, you're accused of speeding 91 and a 65, a traffic infraction that does not carry jail time, but a scheduled fine if you were to be convicted in court costs. Count two, operating a motor vehicle without proof of liability insurance. A B misdemeanor, the fine could be $300 to $1,000 and up to 6 months in the county jail. If you did have insurance, but just didn't have proof of it, you can get that to the county attorney and they may dismiss that. But if in fact, just to happen that you didn't have insurance, you may be able to apply for diversion. Well, you can apply for diversion. From what I can see, you have something on your record for traffic, but it looks quite old. About 11 years, so you may qualify, I don't know. Are you interested in diversion?
If I don't do, sorry. If I don't do diversion, is it possible that my license could be suspended?
Well, Topeka controls all of that through Department of Revenue. But they do make you file what's called an SR-23. I think you have to provide proof every month of insurance. It goes down as a Class B misdemeanor on your record. You could have jail time, although probation is usually granted. There is the minimum $300 fine. But you have the right to plead not guilty and set it for trial. You can plead guilty and proceed with sentencing today, or you could plead no contest, which doesn't admit it, but it doesn't deny it. You'd still be found guilty and proceed with sentencing. Do you still live in Kansas?
I do.
Well, what's this Sedgwick County doing? Okay, I don't know. All I'm seeing is the current traffic and the 2014 speeding. I see some civil incidentals on here that I don't think would have an effect on you. But I don't know. Do you want to look into it or not?
I'll look into the diversion, yeah.
All right, so I will set you. There's no, well, September 20. September 24th, 9 a.m. That's going to be so far away. I don't want you to forget that you have court. But if you get in there and get your diversion started, and you may not have to even come back on that date. You will need to get your picture and prints taken, so go into the breakout room with the officer. Your bond is set at 1,000 OR. If you decide, if you don't get the diversion and you decide you want to apply for court-appointed attorney, contact the courthouse and do that right away. Don't delay. Of course, you can always hire an attorney. I don't know if I'm correctly sensing some apprehension that maybe I need to answer some questions for you.
Do I have to pay anything today, or is that what the diversion does?
When you apply for diversion, there is a diversion fee. Now, you don't have to necessarily do that today, but they can't process your diversion without the payment. Are you going to need some time to come up with the diversion payment? Is that part of the worry? I know a lot of people have that worry.
Is it a lot usually? How do you know how much your diversion payment will be?
If you go to that website, bucoks.com, it will tell you what it's not cheap. There is an application fee, and then there is another fee if you're accepted. And I keep meaning to look that up because I hear that question a lot, and it may be well over $100 each time. I'm not sure. But as far as payment of your $300 fine and your court costs of $108, I believe they give you some time to pay that over the course of the diversion, but you will have to put some up front. Do you want me to recess your case and let you go online and look at that and then bring your case back up later in this docket?
What does that mean?
Well, that means I can take a break and let you go look up the website and then call your case again in an hour or so and see if you want diversion or if you've decided it's definitely not for you. It should answer the questions about how much it costs and when the money's due. You want to do that? Do you have access to this?
Yeah, I need to look into it because the money thing's gonna mess me up.
Well, I understand. So, all right, well, I'm going to recess your case. Go ahead and go into the breakout room with the officer and get your picture and prints appointment set up. Then go online and I'll call your case here in a little bit again.
The breakout room.
It'll pop up on your screen. And do you have the website for diversion? Did you write that down? It's short for Butler County, Kansas. bucoks.com.
Yeah, I have that.
Okay, but right now look for Missy to put invitation to a breakout room and deputy $1,000 OR. She won't put the money up unless she fails to come to court, of course.
That was interesting to watch just because Judge Webster had a lot of patience with her, despite the fact that she was so indecisive on things, and often you do not see that with a judge. They want to move things along, so that was different. I could have done an entire show today just on the Louisiana Board of Parole and Pardon. They've been going on forever, but let's do another one. We had one success earlier today. Let's see if we can get two.
Okay, do you have your parole questionnaire with you?
Sure, I do.
Okay. Do you understand you were not eligible for appointed counsel?
Yes, sir.
And that if you wanted counsel, you would have to hire it, but you are represented by the Orleans Public Defender's Office. Okay. All right. So you wish to proceed today?
Yes, sir.
All right. First off, we have joining us is Mary Ella Simmons, Orleans Public Defender, and Brian Loyce, Orleans Public Defenders. I'm gonna have y'all speak at the proper times. But right now I am gonna read the conditions that you are alleged to violate. And you either plead guilty or not guilty with or without a statement. Okay, and just leave it at that. And your case has been assigned to Mr. Barra, and he'll ask you specific questions about the violation. Do you understand? Okay. All right. First, it is alleged you violated condition number 1. You failed to report your probation and parole at any time since your release from Raven Correctional Center on 9/6/24. How do you plead to that charge?
Not guilty.
Okay. Condition number 4. Condition number 4, you failed to refrain from criminal activity as evidenced by your arrest on or about 9/12/24 by the New Orleans Police Department for a battery of a police officer, simple assault, misdemeanor sexual battery, criminal trespassing, third offense, theft and resisting an officer on 4/9/2025 under Orleans 563720. You pled guilty to criminal trespass, third offense, and misdemeanor sexual assault, simple assault, theft under $1,000, resisting an officer, and battery of a police officer. You were given credit for time served with added special conditions. How do you plead to that charge?
Not guilty.
All right. First, let's hear from Miss Mary Ella Simmons, Public Defender's Office. You're on mute, ma'am.
Can you hear me now?
Yes, ma'am.
All right. Sorry about that. Good morning.
Okay.
Thank you so much for the opportunity to speak to you on behalf of Mr. Leyburn. My name is Mary Ella Simmons. I'm a staff attorney in the Orleans Public Defender's Office, and along with social worker Brian Lars, I've been working with Mr. Leyburn for a little while now. What I'd like to emphasize for the board is the short time span between when Mr. Leyburn was released from Rayburn Correctional Center on September 6th of last year to when he was unfortunately arrested on September 12th. Mr. Leyburn was out back in the community for about 6 days when he made a series of poor choices, reverted back to some old patterns, and found himself at a location in the French Quarter and then in the back of a police car. I think that, and Mr. Leyburn now has been in jail for 9 months and has taken responsibility for his actions by pleading guilty. And I would note he only pleaded guilty to misdemeanor charges, so no new felony charges. As I'm sure the board knows quite well, it can be a really disorienting experience to be released from prison without a lot of immediate support or direction, and in Mr. Leyburn's case, without any sort of supportive family or social worker or friend structures. And Mr. Leyburn really immediately struggled and spiraled. What I think could be different this time, and I do believe would be different this time if the board chooses to give Mr. Leyburn a second chance, is the newfound support that Mr. Leyburn has worked with Mr. Lars in our office to set up. If the board chooses to give Mr. Leyburn a second chance on parole, we would ask that he be released to OPD so that we could help him kind of immediately transition into that higher level of support and engagement that would ensure that he does better on parole this time, and actually is able to, do parole, which 6 days is not really much time at all. So given that he has now spent 9 additional months in jail, I would just ask the board to consider giving him a second chance to demonstrate that he is in fact capable with additional support that we can provide, capable of fulfilling all of the requirements and doing a lot better. Thank you.
Okay, thank you. Okay, Mr. Brian Lars, is Mr. Lars with us?
Yes, can you hear me, sir?
Yes, sir.
Good morning. My name is Brian Lars. I'm a social worker at the Orleans Public Defender's Office. Good morning, board members. Yes, and I apologize. I have to use my phone. I'm having issues with my computer, but at any rate, Nicholas acknowledges that he has not done everything perfect. But let me just tell you something. Nicholas Layburn is the classic example for someone who needs the services that I've listed in this reentry plan. He's the classic case. All of his past arrests is directly related to his homelessness and lack of immediate support. Nicholas, so yeah, like Mary Ellis just expressed, we hope that the board will consider this a plan. We hope that the board agreed to release Nicholas to me. He'll be coming to me, and I'll directly bring him to the homeless shelter, get him in a shelter. I also will make sure that he go to Metropolitan Human Services, where he'll undergo a psychiatric evaluation because he has some mental health issues related to PTSD. Imagine being homeless for 14 years, what that does to your mental stability. He needs help. He really needs help. And listen, being a social worker, you get to understand and learn about clients on another level. Nicholas really is an educated young man. He went to one of the best high schools in New Orleans. He just lost his way. And I'm here to help him. He don't really deserve, listen, he made some mistakes, and I'm sure he'll talk about that and acknowledge some of those things. But listen, he's a good person. He just needs some help. He really does. So I detailed, list of things that I'll be doing, and I'll be working directly with Nicholas. I'm gonna refer him to First 72 as well, where he can, attend some peer support classes, work on getting some employment, but really want him to get the psych eval, to address the PTSD and trauma. Being on the streets for 14 years, that is very difficult. And I'm telling you, all of his arrests is directly related to his homelessness. It really is. And so we hope that the board consider this plan. I'm gonna be working directly with him. And like I said, I'll pick him up from OJC, bring him to the shelter, and I'm also facilitate the process of him going to Metropolitan Human Services. I'm gonna work with him. He'll have access to our office to work through any kind of difficult situations. So we hope the board consider this plan. Thank you.
Thank you. Okay.
I'd like to move to go into executive session for a moment, please.
Okay, we have a motion for executive session and a second. Call the roll, please.
Courtroom.
Yes.
Yes.
Yeah. Okay, we have a motion for executive session, which has been approved. We're gonna go into executive session to discuss confidential matters. We'll be right back within a few minutes.
Okay, so the good news is that we were in the Wayback Machine here a little bit. So give me just a second and we can move past that and see what happens. Okay, here we go.
In regular session. Okay, your case has been assigned to Mr. Byra. Please answer any questions that he has for you.
Mr. Lieber, I noticed when Mr. Freeman was going over the violations, you pled not guilty to number 4 with all those charges, but you pled guilty in a court of law. So how can you say you're not guilty after you've already pled guilty?
Yes, sir. The violations on those charges were stemming from events that happened over the course of 2022 and 2023. Before the discharge and parole on this charge took place.
Trying to say he had charges against him before at that same group.
All right. That was the only question I had.
Okay. So when you went, you didn't realize you pleading to new charges?
Well, my attorney advised me to go ahead and plead not guilty, and I'd have a chance to explain.
Okay. All right.
Well, then go ahead and explain why you did such a thing.
It was that the charges the events that led to the charges took place prior to this charge, prior to 2023, when this charge originally, it was from May 2nd of 2023, and all of the allegations in this new set of charges happened before that in 2022 and 2023.
And that's not what we have.
Yeah,
No,
that's not-
these are brand new charges. This has nothing to do with 2023.
May I, could I
I
possibly
know what he's, oh, yes, ma'am, you can.
just offer some clarity? I think that at the parole prelim, I had explained to Mr. Leyburn that pleading not guilty offered an opportunity to have further discussion. And I think that he may be applying that logic to this situation. And we have, there was some confusion because he did have a previous case involving similar allegations from 2023. But as we've discussed, Mr. Leyburn, which I think you will remember, the charges these new charges that were in Section I of CDC came from September of 2024.
Okay,
That clears it up.
thank you. All right, I have no questions. Ms. Ledoux? Okay, Ms. Bauer, are you ready to vote?
Yeah, Mr. Leyburn, you leave me with no choice but to revoke your parole based on the fact that you pled guilty to multiple charges, including sex charges, battery on police, only 6 days after your release. And the fact that you're a third offender, you know better than that. So that's you leave me no choice but to vote to revoke your parole.
Ms. Ledoux?
My vote is to revoke based on criminal behavior. And I would make note, Brian, that the plan for reentry is not something I have confidence in his success in. My vote is to revoke.
Okay, my vote is to revoke, find him in violation of condition number 1 and condition number 4. Today, your parole has been revoked. Good luck to you. We're signing off at Orleans at 9:55.
Well, there you go, friends. We were 1 for 1 today, or 1 for 2 rather. That's better than we normally get out of there. But again, I like to go to these, number 1, because it's good for us to debate in the chat. But it's interesting to listen to what these people have gone through, what they're trying to do to get better, where they're failing, things like that. I feel like when we go to these, we see much more of what's going on in the defendant's actual life than we see in the normal court proceedings. So something different that we don't otherwise see, in my opinion anyways. So we'll go ahead and leave it there for today. We'll be back tomorrow at 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. And yes, it will work tomorrow. Channel members, again, I apologize for having to punt on the pre-show today. Sometimes tech just gets in the way, and this morning it definitely got in the way, but managed to get it corrected fairly quickly and make lemonade out of those lemons, and got to start the live show a little early, so there was that. I'm going to go do an escape room later today with my daughter and my son and my wife, so that should be fun. Whatever you guys have planned for your day, I hope it's great. But again, we'll see you tomorrow. In the meantime, take care. God bless.